You watch.
Yes.
My lord,
May I leave mention this matter, my lord? This was mentioned on Monday, my lord. Due to urgency, I am.
All applications, whoever is mentioning upon notice, please hand over these slips. All applications which are mainly mentioned.
এটা নায়কের মতো লাগে।
Yes, Mr.
Not
Sharma.
with just leave of Justice Mitroman, I'm mentioning before.
Please wait. Yes, any other mentioning?
File has not been received by the department, so twice I attempted.
When was the order passed, you said?
23rd,
And you applied on?
9th after the first day of the opening.
Leave granted.
My lord, matter was due to appear 1 week after vacation, my lord.
Does not come.
Not come.
All right, hand over this slip. Yes, any other mentioning in this bench?
Business side matter, my lord.
Original, আরে এই কার্তিক এই অরিজিনাল সাইডের লোক থাকে না কেন বৃহস্পতিবার আর সোমবার? হ্যাঁ 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 you have given notice. এটাকে টু বি মেনশনড দিয়ে দিও, প্লিজ কিপ আ ওয়াচ অন দি লিস্ট, ইট উইল কাম। বলে দিও withdrawal আছে। হ্যাঁ,
My lord, I am praying for leave to file the memorandum of appeal with the server copy.
When the order
Order
was
dated 17 June 2025.
applied.
Applied on the same day.
We are on 20. Today we are on 19. 20.
17 June 2025 this year.
So what is the urgency, sir?
My lord, urgency is that, my lord, the respondent authority has padlocked my factory premises. And this, the consignment of the petitioner are under there, and there is a huge possibility of loss.
Possibility. So you await the possibility, get the certified copy and file.
My lord, that will take some time, my lord. Kindly, my lord.
We don't find such tearing hurry in this matter. What is the urgency, sir? Your factory has been closed down.
My factory is the consignment of the petitioner is in the premises of the respondent authority. Respondent authority padlock the factory. My consignment is under their
প্যাজিনেশনও করা হয়নি,
warehouse, my lord.
Not paid.
প্যাজিনেশনও হয়নি।
Not paid.
Lordship, may I permit?
Granted, leave granted. Yes, any other mentioning in this bench?
Original site.
Lordship, may I permit to mention? Lordship, I am mentioning for inclusion, your lordship. It's a residuary matter under.
Appeal in hearing. It is final here. Appeal. Application.
No, lordship.
Then-
It's inclusion, your lordship.
Inclusion, we have to include something, madam. Is it an application or is it an appeal hearing?
Lordship, it's appeal.
Appeal hearing.
Appeal.
Paper books filed.
Yes, lordship.
Which year appeal?
Your lordship is a 2020 this year appeal, lordship.
পেপার বুকস হ্যাভ বিন ফাইলড।
Yes, lordship. Everything. is-
Original side matter.
No, lordship. It's a appellate side matter.
All right, give this slip.
Pleased to mention a matter. This is a writ appeal on the original side. I'll just indicate the urgency. This is the petitioner is seeking directions upon the fire
Sir,
safety.
please give a notice and come back on Monday.
I have served notice.
It's an application.
It's a writ appeal where the directions have been passed on the fire safety authority to carry out the fire safety measure. Previous 2 months, there have been incident fires on the adjacent buildings.
The
I am-
Justice Sinha's order,
No, no,
which
no.
we passed.
It's independent appeal where the writ petitioner approached the court for installation of the fire safety mechanism,
Hmm.
seeking directions about the state fire safety, and the petitioner is not occupying the premises. The difficulty which the petitioner is facing is that the adjacent 2 buildings have actually got a fire. It's in the Russell Street. So the petitioner is only seeking directions. There has been a direction passed on the fire safety authority to file a report and take
Whether the application was heard earlier,
hard earlier.
then not disposed of.
It's
as
not
yet.
disposed of. It can be.
You have exchanged your pleadings in the
Yes,
application.
everything is done.
নিয়ে রাখো তো, আর এদেরকে বলবে সোমবার আর
Grateful.
বৃহস্পতিবার এখানে থাকো। Yes.
My lord, I pray your lordship's leave to file this application, contempt application on urgent basis and take it up at 2.
Why?
Because I tell lordship, even after your lordship's order, staying the operation of all the notifications, admissions are going on. So, my lord, indicating OBC A and B.
No, it will be a follow-up action, Mr.
No,
Sharma.
that's
If
from the
anything is
it's a
done-
contempt application.
No,
Yeah.
it cannot be taken up in that fashion. We have already stayed the notification. Now, if any action state takes, that will be open to contempt. There is no such art.
No, that's why we are paying for your lordship for hearing on urgent basis.
No, no. There is no such. We have kept it. You can file the matter. Let it come. It will appear on the whichever.
The entire thing will be over then by this time. Before it
But
losses.
it will not be over, Mr. Sharma.
Well, that's
You will be there.
that's but the that's happened in on the earlier occasion also.
Mr. Shandal, we have passed an order. Now, if the state,
I understand your lordship's point. It's not that I'm not
so
understanding.
if we take up your contempt also, at best, what order we will pass? We will issue a contempt rule. So it is not a case of fresh interim order to be granted, otherwise you will suffer. If third party right is created by the state in spite of our direction, consequences will follow. That much we can say. Yes, call the list.
With the leave of my lord Justice Mitro, my lord, may I be permitted to mention one review application, my lord, passed by your lordship, sitting with my lord Justice Pathur Sharati Chatterjee, my lord. Grateful, my lord. Has served, my lord.
My lord, I am for the private restaurant. My lord, kindly grant me a short passover, my lord. My senior is appearing in a
Who is your senior, madam?
advocate Tanmoy Basu.
This is the fourth, I
My-
think, third occasion.
My lord, just a short passover. Kindly grant me a short passover, my lord.
Pass over. Yes.
Safeguard has given a report to বারবার সাবমিশন করতে বলেছে রেকর্ড করিয়ে দেয়
নাম্বারটা একটু সার্ভিস করতে পারে
রেকর্ড করিয়ে দিই
780
ওকে
Yes. Yes, Mr. Bikram Bennett.
My lord, I am for
Lord,
the
I am
private
for the-
respondent. I am for the private
petitioner.
respondent.
You are private.
Well,
You are the petitioner.
Yes, my lord.
Yes, what has happened now is a custody problem.
No, not a custody problem, my lord. The fact remains, my lord, on October to September to 28th
Now
October
the children are with whom?
with
My
the
lord, with
father.
me.
With
My
the
lord,
father.
forcefully taken away. That is my contention. That is why I have come up in habeas corpus. And your lordship knows, my lord, Hindu Guardianship and Minority Act. If a child is below 5 years, custody has to be with mother. Well, one of the male child, my lord, is 4 years old. Forcefully taken away. He is my lord, civic police. He is an influential person of the society. There may be some matrimonial dispute, my lord, but no one can forcefully take away the child. If he wants a custody of the child, he has a proper remedy before the court. This is my respectful submission, and my lord, there are ample number of judgments.
What do you do? You are the mother.
Yes, I am the mother.
What do you do? You are a serving lady.
No. My lord, mother, my lord, in
So
village areas, my lord, mothers only take
No. First of all, they are 11 years and 4 years.
11 years and 4 years.
So if there is a matrimonial dispute between you, must be there is a matrimonial dispute.
There is a matrimonial dispute. The husband does not stay with
So,
me.
Can it be said to be an illegal detention prima facie?
My lord,
He is
forcefully taken away. My lord, kindly visualize.
force that will be a ground for visitation rights you are entitled to. Go under the Guardianship Act.
My lord, Hindu Minority and Guardianship Act,
Hmm.
my lord, it categorically says the minor who has not completed the age of 5 years ordinarily shall be
Yes,
mother.
ordinarily will be the
My lord,
mother.
it was with me. It has
We
been
do
taken away, my
establish
lord.
that.
My lord, it has.
My lord,
Yes.
the wife, my lord, after 12 years of marriage, has lived with another boy. She has
These are
married.
bad
has-
allegations, my lord.
She has married another.
Don't say it is a bad allegation, improper allegation. Maybe.
Bad allegation.
Yes.
My lord, she has married another boy. She has posted those pictures of her marriage with another boy in social media platform.
How
These
he
are the
is getting that
pictures.
pictures?
My lord, in the social media
Show
platform.
that social media platform.
When
So
did
that
you, why did you,
My lord, she has
now
deserted
she is living with, now
with
she is,
another boy.
no.
all right, that is your plea.
And my lord,
Where are the children
my lord,
studying?
my lord, I have, my lord,
in my
Sir,
report.
why do you bring the children to court? Have we asked?
no, my lord. My lord, they have brought, my lord, the husband, my lord, the children are studying in the school near to my location. My lord, the daughter is aged about 11 years. The boy is aged about 4 years. My lord, they are studying in school near to my location. My lord, I personally had an interaction with the children. They said that the father even, my lord, the grandparents are even with them. My lord, the mother has left them with the other boy and my lord has
My lord,
deserted them.
what will happen,
My
my lord,
lord,
like this, my lord, if I cannot
my lord,
visit my
he
child
has,
for the last 7 to 8 months, my lord, the
We shall
children
hear
will
you,
be
we shall-
brainwashed.
We shall hear you, Mr. Bennett.
my lord, he has suppressed in this habeas corpus application even that earlier he has filed an application under section 97 of the Code of Criminal Procedure. My
Hmm.
lord, praying for a direction upon the learned magistrate for search of my son by the police officer. My lord, such order was stayed by the learned revisional court. My lord, that fact has been suppressed here. And my lord, now in this habeas corpus application, he is wanting the custody of the children. My lord, the children are now with me. My lord, I
My lord, at least I should have some visitation right, my lord. That as a biological mother,
We are keeping it after 2 weeks, Mr.
my lord,
Bennett.
visitation right, my lord, at the police, my lord, kindly give some direction because I have prayed, my lord, I can't
has
even
left
visit it.
me. My lord, I did not
My
desert
lord,
her.
mother will
She
run
has
after
left
door
me.
to door
She
and
had filed
my
an
lord to the
Are
police
you
station.
residing with another person?
No, my lord, I am residing in my father's house. Absolutely, my lord, false allegation, my lord.
Very good. Very
My
good.
lord, she
My lord,
has filed
visitation,
a
my lord, so far as
498
visitation,
We
right,
shall look into it, Mr. Bennett.
my lord, kindly allow the
These are-
visitation.
Be considered.
My lord, kindly allow the visitation, right, my lord.
Milord, these are all matters of fact, Milord, which requires adjudication under section 8 of the Act, Milord. Milord, because the learned trial court will have to go into the merits considering the paramount interest of the child, Milord. Milord,
Hmm.
in habeas corpus, Milord, as of now, there is no illegal detention because custody of the father cannot be set to an illegal
illegal
detention.
detention.
She is the natural guardian now, below 5 years.
But
She is
Milord,
the natural guardian now.
My lord, if
I do not know, Milord, every day I learn from your lordship whether there is any scope by this court.
Court in exercise of
Yes,
writ jurisdiction.
that is
There
that
are,
is
my
always
lord,
there.
my lord,
That
ample
is
number
always-
of judgments in this regard.
that is always
My lord, kindly allow at least a interim period to last 8 months, my lord. I could not see my both the children. Last 8 months. I was compelled to come up in habeas corpus, my lord.
my lord,
At least visitation, I cannot even see how they are.
my lord,
I
she
was
has,
not allowed, my lord. I've been thrown out from my.
my lord, she has filed her 498 application against the husband and
He has filed
deserted me.
he has filed a divorce petition, my lord, against me.
My lord, after only she has deserted me.
Dear Mr. Bennett,
The criminal bench appearing before your lordship after law. Grateful.
But I am for the appellant. Last occasion, your lordship, but there are directed private respondent, not 5 to 8. Your lordships on the last occasion directed me, since no one appeared on behalf of the private respondent, to serve both the parties as well as the learned advocate who appeared before the learned single judge. The learned advocate refused to accept. The envelope was in respect of one of the party, respondent number 8, it has been served. But 5 to 7, it is the from the tracking report, it appearing that the item is bagged. But respondent number 8 is concerned, it is received.
Same area.
Same area holo bolte to hobe.
Yes, Mr.
What does the tracking report show?
That tracking report. Track
5 to 7, what does it show?
yes, 5 to 7 is item bagged.
Item?
Bagged.
Packed.
Bagged.
Not served.
Then not served yet.
Yes, only 8 it has been served. That is the track report, as on the day.
Monday.
Track report. May I take back the affidavit of service
Yes.
so that I can ascertain the current position and come back?
Come on Tuesday then.
Tuesday.
That's what.
Ready. Track report to the
আজকেও দেখেছি
I make sure. Which date?
একটু বড় ব্যাটালিয়ন নিয়ে এসছে।
I am appearing on behalf of the transmission company.
That I am challenging the order dated 14th of January 2025.
You had the read petition.
Yes. This is the evidence service. I am also praying for leave.
Private respondent is there.
No. Yes, it's delivered. Delivered.
Yes, Mr. Tiwari, what has happened?
Now, what happened, the land of the petitioner, what they have done, I am the owner of the land in question. Now, transmission company, had taken overhead line over my land. Now, initially, I approached this Honorable Court. This Honorable Court, this Honorable Court had been pleased to say that the writ petition has become infructuous, as because they have already overdone the line over your land. Now, challenging that, I moved the Honorable Division Bench. Division Bench says, when the writ petition was filed, that was not the situation. So, it cannot be said that it has become infructuous. The Division Bench directed the District Magistrate to make an inquiry and proceed in accordance with law. The District Magistrate, what the District Magistrate has done, District Magistrate heard the parties. Ultimately, District Magistrate held that it is for the public interest. So, land is rightly taken and you are entitled to get compensation. Now, what they have done, if they have taken the line in a state way, then my land would not have been affected. But they have they have taken the line in a V-shaped manner. Ultimately, prejudice my land itself. I just show you, kindly see, the order of the Division Bench first. It is at page 84 of the.
Mr. Tiwari, we delivered a judgment on this issue, I think. You were there, na? Sitting with Justice Raja Bosu Chaudhuri, we delivered a judgment on the DM's order.
Yes, but actually the point of law would be
Achha,
the
then let us
transmission line. It cannot be drawn in a
So, writ petition was on affidavits,
Writ petition was not on it.
not on affidavits.
What happened in the notification issued by the transmission
So,
company?
Mr. Tiwari, there is no scope for any interim order.
There is no scope for any. Only one thing I am amazed.
Yes, yes.
What they have done,
You are showing us.
Yes, your lordship, kindly turn page 84. This is the order of the Division Bench. Kindly turn page 86. Paragraph 10.
Yes.
No, my lord, may I just place it. Thus, on the day when the writ petitions were filed, it appears the high tension line was not drawn. Therefore, we have the view that the objection raised by the appellants for drawal of the line over and above their property has not become infractuous, and such issue can be adjudicated by the district magistrate, despite the fact that during the pendency of the writ petition, high tension line has been drawn. Therefore, we dispose of this appeal by directing the appellant to submit a fresh representation along with a copy of this order as well as a copy of the representations and submitted the district magistrate, and same shall be inquired into after notice to the transmission company as well as the appellant, and after affording an opportunity of hearing to the authorized representative of the appellants. The said representation, it will be well open to the appellants to make alternative pair for claiming compensation, which will be without prejudice to the appellant's right to contest the drawal of the line over their property. The district magistrate shall pass the final order after conducting the inquiry within a period of 6 weeks from the date of representation is submitted. Now, my lord, your lordship, my lord, kindly turn, my lord, page 79 once.
Page 79.
Nine.
Yes.
Well, this is the way, my lord, they have drawn the line over the land. Now, my lord, kindly see, my lord, the straight way comes, thereafter V shape, then again straight line.
Where is your land?
My land is, my lord, in the curve, in the V area.
So had it been taken straight,
Straight.
your land.
My land would have been saved. Now, my lord, kindly take, my lord, the DM's order, my lord, field inquiry was conducted. Now, my lord, how, my lord, why this line was changed? My lord, kindly turn, my lord, page 129.
Yes.
Lord, in page 129, I'll be just placing, Lord, the joint inspection report, which was made a record in the DM's order. Kindly see, where at first, second, third, fourth paragraph, whereas it appears from the joint inspection report, joint inspection that 0.03 acre land in the recorded in the name of such and such, 0.03 acre recorded in the name of such and such in respect of plot number 843 and 844 of Moja number such and such. During inspection, it was found that no tower foundation or the tower legs have been erected on the land of the petitioners. The line was drawn as per the final report of the survey conducted by the concerned authority, which was finalized and approved in 2019. During the inspection, it was noticed that the safe electrical clearance from the above constructions, building or already construction FL shop, namely such and such, and another existing plot number 132 kV DC line, and the line was drawn in a manner as mentioned in the finalized route alignment, which is not in straight manner. If the line is straight manner, it may affect the land of Subhash Chatterjee foreign liquor shop and adjacent building. Kindly note this. This is the private respondent, before your lordship. There are 12 people who have contributed their land by accepting compensation for installation of the tower and draw the high tension line over their land for Tarakeshwar Jangipara transmission their line project. The representative of the WBSETCL tried verbally for negotiation with the petitioners, but they did not respond. However, no documentary proof have been found regarding the negotiation approach by the WBSETCL to the petitioner. The overhead tension line were passing such and such and such. Next, my lord. Whereas for the reply and report of the WBSETCL as received with the joint inspection report, it appears that it is natural phenomenon and regular event that the initial survey and the final survey does not match to each other. Initial survey was conducted in the year 2016-2017 and finally approved in 2017 for estimation purpose. So, my lord, initial survey was something, subsequent survey was something. In the initial survey, my lord, land was not there. In order to save the land of my lord one Subhash Chatterjee, my lord, this has been done.
But Mr. Tiwari, how can we now direct in 2025 that you cut the transmission line and draw it in this. We are not technical experts.
The technical expert, my lord, everything has been done, my lord. Kindly consider.
Mr. Tiwari, how can today what you are wanting is that you remove that from my land? Alternative route you take. That, Mr. Tiwari, how it is feasible at this stage?
My
It
lord,
is a transmission line.
statute provides so, my lord.
It
They
will
cannot
break
act, my
down
lord.
the entire
My lord,
consequential.
my lord, kindly see, my lord, the trial judge has proceeded, my lord, on the basis, my lord, initial, my lord, advertisement was in respect of district of, my lord, Malda.
No, we are asking you, Mr. Tiwari, how can we disturb that line now? Please, you give us some
But
authority.
it can be, my lord, straight way, alternative way that act provides.
Such transmission line is existing there since 2020. Approval of transmission was in 2019.
Approval was there on 2019, but it was subsequently done. Subsequently done.
Petition was of 2020
But
at
when
the
the
time we were doing the construction.
yes, prior
20. Now it has been drawn, it has been finalized. So that is why the alternative prayer is there for compensation.
no,
But
compensation prayer, Miller, kindly similar for my land. Kindly, I'll be just showing to you, similar
they
to
have not quantified it as yet.
3,000 rupees.
Where they have quantified?
Quantified at 3,000 rupees.
Where?
My 6 acres of land in the supplementary available, your loss you would get it. When I have used a supplementary affidavit with a copy to my learned friend, page 6 of the supplementary affidavit.
So you challenge that order before the
No, kindly
court?
consider one thing, Milord. Two, I will be making Milord submission, Milord, that everything has been done, Milord, for the purpose of saving a particular person.
After my objection.
Milord, this is the appeal.
But Mr. Tiwari, we are in appeal.
Yes.
The order which you have appealed, ultimately the coordinate bench judgment has been implemented. Now what remains in
The
this
coordinate,
appeal?
kindly see the how the Milord, the honorable single judge had proceeded in the matter. Milord, may I just place the Milord, honorable single judge's order?
Thank you. You are coming before against which order?
The order dated Milord 14th of January 2025.
14th of January. Where
It is a memorandum of appeal.
That is after the DM's order.
Yes.
Oh, you challenge the
Yes,
DM's
yes,
order.
yes.
Oh, yes. Now what has been stated?
May I just place it, Milord? That is 14th of January 2025. The petitioners agreed by the order passed by the District Magistrate Hooghly on 21st August 2024 by disposing the prayer of the petitioners, directing the transmission company limited to determine the compensation and disburse the same to the petitioner for any damage sustained by him. High tension line have been drawn over the land of the petitioner. According to the petitioners, the lines have been drawn in a V shape. Had the transmission line been being drawn straight, then the land of the petitioners could have saved. The petitioners also submit that the impugn order of the district magistrate mentioned the advertisement published in the Delhi newspaper on 5th August 2017. The petitioners point out the advertisement and submit that the same has been published in the district of Malda, not in the district of Hooghly, where the land of the petitioner is located. The aforesaid advertisement dated 5th August 2017 cannot be applicable in the case of the petitioners. The prayer has been made to direct the transmission company limited to alter the transmission line to save the land of the petitioners. The London Council representing the transmission company limited submit that the transmission line is required to be drawn as per the alignment. The same cannot be drawn as per the convenience of a particular party. It has been submitted that the petitioners failed to raise any objection within the time as specified in the advertisement dated 5th of August 2017. It has been submitted that as per Rule 3.4 of the Works of License Rules 2006, the said rule will not affect the power conferred upon the licensee under Section 164 of the Electricity Act 2003. The petitioners refers to Section 3B of the Works License Rules 2016 in support of the submissions that the district magistrate has the power to direct removal or alteration of the overhead lines. I have heard the submission of on behalf of both the parties. Next, Milord. The submission of the transmission wire have been drawn in V shape cannot be addressed by this court because court is not the expert body to decide such issue. The transmission company limited has submitted that the transmission line were drawn as per alignment of 132 kV high tension line. As regards the submissions that the advertisement dated 5th of August 2017 refers to the district of Malda and could not be made applicable in the district of Hooghly, where the land of the petitioners is located, cannot be accepted. On perusal of the advertisement, it is evident that the same is in respect of the Tarakeswar Jangipur transmission line,
The police stations mentioned in the advertisement will relate to the district of Hooghly. None are in respect of district of Malda. The name of the project, that is Tarakeshwar Jangipara transmission line, has also been clearly mentioned therein. It may be that the petitioner did not notice the advertisement at the proper time. Accordingly, the objection could not be raised. The district magistrate has already directed the determination of compensation by the transmission company limited and to disburse the same in favor of the petitioner for the damage sustained by him. The transmission company limited is directed to act in terms of the directions passed by the district magistrate and determine the compensation and disburse the same in favor of the petitioners. The petitioner shall be entitled to produce a proof of the damage sustained by him because the drawing of the high tension line over his plot of land. The transmission company limited shall conclude the determination of compensation and disbursement of the amount of compensation at the earliest, but positively within a period of such and such. Now, learned judge will not held that the notification is in respect of Malda.
Without any collision.
Well, there is no identification of the land. I was not in a position to raise my objection. Well, I can show to your lordship that the notification which is published, kindly turn page 126. Kindly have a look, the notification published by the notice published by the transmission company, page 126. In the page 126, your lordship will find in the first paragraph, last line, মালদা জেলার নিম্নলিখিত মৌজা সমূহের মধ্যে দিয়ে প্রস্তাবিত লাইন টানা হইবে। মৌজার নাম জেল নম্বর বন্ধুরের মধ্যে উল্লিখিত, পুলিশ স্টেশন জঙ্গিপুর, ধর্মপুর, চণ্ডীতলা, সাজেন্সা. These police stations are in the district of Hooghly, but they are saying it is in respect of Malda, and not only that, there is no identification of the land in question. Only Moja number has been mentioned. But in Moja there are several plots of lands are there. How could I identify myself? My land will be in respect of these Mojas or not? This notification or these notice will not absolutely contrary to the law itself.
Now, after this order, has any compensation has been determined?
Compensation determined 3,000 something. You will lordship will get it in the supplementary affidavit. I have used a supplementary affidavit.
So you challenge that, Mr. Tiwari.
I am challenging I am today, your lordship, kindly consider. Today, it has been done on a public purpose. There is no doubt about that. Public interest is involved. There is also no doubt. But whenever you can protect the interest of a particular individual, why not me? Kindly see the report. In the report, it was specifically stated that it has been done just to save that particular person.
Impugned order.
And impugned order, kindly consider that fact also. The impugned order, Lane judge proceeded on the basis, yes, there was some mistake some mistake in mentioning the name of the district. But in the until unless Moja is there, plot number is there, how could I identify my land? I am asking the question to myself. Inspection report proceeded on the basis if the line drawn in the straight manner, it may affect the land of Subhash Chatterjee. So that's why they have adopted this process. The V shape was process of taking the line in a V shape only for the purpose of saving the Subhash Chatterjee. He has been favored. Had it been a straight line, this is my only land. 6 decimals, due to this, my entire 6 decimal land will go. And they have calculated compensation 3,000 and odd.
You are free to challenge that. You are free to challenge that.
I am free to challenge, there is no doubt about that, but kindly consider the way the district master had proceeded. Lane judge did not take care of all these things. The way district master had proceeded, kindly see, it is apparent the district master had proceeded just to save one particular person.
Transmission line
Telegraph Act, my lord, says, my lord. Section 70.
Yes.
Okay, my lord, your lordship, my lord, kindly takes, my lord, section 10 of the Telegraph Act, 10D. This is the thing. Ten D, my lord, it's part 3. It says, my lord, power to place telegraph lines and posts. The power for telegraph authority to place and maintain telegraph lines and the post. Now, kindly tell me, my lord, 10 clause D. In exercise of power conferred by this section, the telegraph authority shall do as little damage as possible, and when it has exercised those powers in respect of any property other than that referred to in clause C, shall pay compensation to all persons interested for all persons interested for any damage sustained by them by reason of the exercise of those powers. So, little damage, my lord, is expected. My lord, what your lordship, my lord, kindly see, my lord, the inspection report says
That is separate. That is you are going to the compensation aspect. You are not wanting compensation. You want the line to be removed.
Lord, it can be, my lord, that kindly tell me, my lord, section 17 once of this act.
Yes.
Section 17 says, my lord, removal or alteration of the telegraph line or post on the property other than that of a local authority. When under the foregoing provisions of this act, the telegraph line on the post has been placed by the telegraph authority under or over along across in any or upon any property not being the property vested, or under the control management of the local authority, and any person entitled to do so desires to deal with that property in such a manner as to render it necessary or convenient that the telegraph line or the post should be removed to another part thereof, or to a higher or lower level, or altered in form, he may require that the telegraph authority to remove and alter the line and post accordingly. So, my lord, this is a complete violation of the act. Absolutely, my lord, complete violation of the act.
Yes, Mr. Paja, you file your affidavit when he is wanting to contest the issue as to whether the transmission line to be disturbed or not. You satisfy us. We told him that you can approach the appropriate authority for quantification of the determination which has been made.
Your lordship is aware that if malefactor is really aggrieved with the compensation amount, he has the right to move to the higher authority.
He doesn't want compensation.
Yes. This
He wants the line to be removed.
The line to be removed because the Supreme Court has already gone into that. I don't want to place it.
That respond number 5 is service is complete. Affidavit of service as file be kept on record. Affidavit of service, comma, as file be kept on record.
I'm not pressed this application.
বলছেন
I'm not pressed the application.
not press.
Not-
You are on record, madam.
No, no, my senior,
Who is your senior?
Sheikh Toshle Mali.
তাও দেখি what is your name, madam?
Rituparna Bhadro.
Do you have any written instruction? Then
Actually, police had taken steps and taken assistance for the petitioner for repairing work of the submersible pump. This is the main matter.
on the prayer of the learned advocate, on the prayer of Miss such and such learned advocate appearing for the appellant, the appeal and the connected application are dismissed as withdrawn. এসছে other side এসছে ওটাতে
Mr. Mundo,
yes come
for the state.
yes yes
But on the last occasion, my lord directed my learned friend to show the my lord plaint of the civil suit they have filed. My lord, kindly see the judge impugned order dated 27th March 2025.
I beg to appear for the writ petitioner respondent number 1. My lord, my name officially, my lord, in all register and documents, my lord, recorded as the owner of the Brickfield. My lord, may I submit my lord the documents? My lord, kindly appreciate. My lord, this is my trade license, my lord, in the name of.
you are admittedly not a partner of the fund, admittedly,
My lord, this part,
because the partnership deed does not bear your name.
but my lord, the partnership deed, the person who entered into the partnership, there is no any authority. Because my lord, on
Who entered into?
my lord, the person, my lord, Devobroto Kanji, who, by whom, my lord, the appellant, my lord, enter into the partnership, the Devobroto Kanji has no any authority to enter into the partnership.
He is Dolon Haldar.
My lord, I am Dolon Haldar.
Dolon Kanji Haldar, he is
I am.
He is
daughter.
Motiur.
She is the daughter of Devobroto.
My lord.
So you are saying your father did not have the authority to enter into the partnership agreement.
No, my lord.
Yes.
Because, my lord, only my name has been recorded. Kindly
Please,
appreciating
please
the royalty,
come to
royalty, my lord. Royalty, my lord. Kindly appreciate. Royalty.
to me, you please come to the partnership deed, sir. It is a registered partnership deed. But it is a registered partnership deed. In the show that Dolon has any share in respect of this partnership business. Show me.
My lord,
You are wanting to, your contention is Devobroto Kanji could not have entered into a partnership.
no, my lord. This Motiur Rahman, registered me to enter into my Brickfield.
You are the daughter of Devobroto Kanji.
My lord.
Acha, very let us. So you are the daughter of Devobroto Kanu.
my lord, and my name has been recorded as a owner.
Recorded as a owner where?
Where, my lord, kindly appreciate, my lord, when the Brickfield has been, my lord, constituted, thereafter, my lord, a West Bengal, my lord, Brickfield Association, my lord, my name is there. My lord, kindly appreciate, my lord.
Who has filed the suit?
There is a Bengal Brickfield Owners Association. My lord,
The child
my lord,
judge records that there is a civil suit pending.
no. Liberty. My lord, kindly, my lord, draw your kind attention. The Bengal Brickfield Owners Association. There is a owners association. My lord, in this association, my lord, it is, my lord, the office in the area of this honorable court, my lord. The Dolon Haldar, the writ petitioner name has been recorded. And not only that, my lord, this is a membership list, my lord.
এখানে যে অ্যাসিডেন্ট সেখানে রেসপন্ডেন্ট ছিল সে অ্যাপিয়ার করেনি বলে যার কারণে আমাদের ডকুমেন্ট ছিল
And my lord, that has been valid up to.
This is wrong, sir. You have been shown as a proprietor.
My lord, proprietor. It is the
Then what happens to the partnership deed?
Because the partnership, if, my lord, they have a claim any right, so, my lord, he has to make a partnership with me, not my father. That is, my lord, my main contention. And kindly appreciate this a membership book of, my lord. Kindly appreciate.
So where is your father? You are not staying with your father?
No, my lord. Because, my lord, I am just kindly, my lord, just please issue your lordships, my lord. My lord, this appellant, my lord, in the Diamond Harbor area, my lord, he is very much well and famous, known as the anti-social. Like, my lord, the Bali Mafia. When, my lord, I am entered into by the strength of the writ court's order, my lord, the act, my lord, offense committed.
You have entered on the basis of the writ court's order.
My lord, impugned order.
Now, entered in the sense that you are Brickfield, you have entered.
My lord. And thereafter, my lord, the act has been perpetrated. Then, my lord, this, my lord, appellant and his main and agent, my lord, perpetrated the act, my lord, that is the outraging the modesty of the writ petitioner. That is, my lord, the FIR, my lord, kindly appreciate.
Complainant.
25th of April, my lord, kindly appreciate.
You're proposing to be the owner of the Brickfield.
My lord, my lord.
So, did you purchase it?
My lord.
Did you purchase the Brickfield? How did you become the owner?
My lord, I am becoming the owner, my lord. My father, when, my lord, the owner, my lord, then, my lord, made a declaration to the DM and all, my lord, the Panchayat authority to, my lord, just transfer the name to right to carry on the business as a Brickfield to my name. That is, my lord, the system of, my lord, this carry on this, my lord, this Brickfield. And that is why, my lord, there is a
how you were the owner?
My lord, because, my lord, from my father.
Your father was the owner of that land?
My lord, at that time. No land, my lord. It is only the business, my lord.
So business, your father was the sole proprietor?
My lord.
Huh?
My lord. That is why.
Then what happened? How it came to you ultimately? What did your father do? Did he execute any instrument in your favor?
Executed, my lord, by a declaration. If, my lord, the person who is a sole proprietor, if he give a consent that my proprietorship has been transferred to any person, he may do any, my lord, the consent to the appropriate authority.
Very good. Now this partnership deed your father had signed.
But, my lord, 2023.
Yes.
When was the declaration made?
Declaration, my lord, on the basis of that declaration.
When was the declaration made?
Well,
when?
My lord, 2000, my lord.
This partnership was of 20.
Very prior to, my lord, the 2021, my lord.
Very good. Then why did your father enter into this partnership deed? If he had given the proprietorship to you, why did he come back again on 23 and execute a partnership?
That is the, my lord, the reason. By influence and by force, my lord. I don't know.
Very good. At that time, you did not raise any objection.
But, my lord, I being a recorded owner in all things, my lord, he has made an clandestine, my lord, the deed of partnership.
These are disputed questions. Can we go into these disputed questions? You have to go to the civil court.
My lord, I will, my lord, go to the civil court for cancellation of the deed of partnership. But when, my lord, on the all the records, when my name is, my lord, there, my lord, how has, my lord, I have been registered by one person, my lord. Kindly appreciate, my lord, it is a the membership book, my lord. This is, my lord, this office in this honorable courts, my lord, where my name is, my lord.
So who is running the business now?
My lord, I was, my lord, running the business, my lord, when, my lord, this appellant came, and thereafter, my lord, forcefully, my lord, occupy the Brickfield, and thereafter, my lord, the running the business. And on the basis of when, my lord, I entered into, my lord, the Brickfield, thereafter, my lord, this FIR has been made. Only on the basis of, my lord, the deed of partnership they claim, but on officially in, my lord, the Bengal book, my lord, the association, this is a book, my lord. My name is there. And I don't know.
Creates a right in your favor. An association has included you as a member. You become the owner.
No, because, my lord.
Say something reasonable, sir.
No, because, my lord.
You have to show us documents that you were running the Brickfield.
My lord, I am the running the, my lord, I have
approached the
royalty papers, and, my lord, this is, my lord, this another papers to the district land and for my application. And thereafter, this is, my lord, the royalty papers.
So in read court, why didn't you annex all these things?
My lord,
when you file the read petition,
my lord, at the time of, my lord, hearing in the read court, my learned friend did not appear. And thereafter, now, my lord, this deed of partnership, my lord, this produced before your lordships, and, my lord, claiming that he is just, my lord, this one. That is the main thing.
He did not appear
No,
before the read court.
My lord, kindly appreciate in the impugned order. Only the state council and, my lord, the council of the writ petition is appeared.
বলছে মতিউর রহমান has 30% share. Partnership deed এ মতিউরের 70%. Page 11. মতিউরের share 70% এখানে। তাহলে কোর্ট রেকর্ড হচ্ছে অ্যাকুইজিশন is Now, what is the present situation?
Present situation, my lord,
You are running the Brickfield now.
I am, my lord, running the Brickfield. I am running the Brickfield, and he is also, my lord, on that Brickfield area running the business.
Same Brickfield area?
Same Brickfield, my lord.
Same Brickfield?
Same Brickfield, because, my lord, the impugned order, there is a, my lord, observation that the 30-70 ratio on the basis of the police report. That is why, my lord, running this business. On that time, my lord, when, my lord,
we are wanting to know what is happening today. You have entered in terms of the trial court.
My lord, my lord.
And who is running the business now? Your Brickfield, who is running?
My lord, appellant. I am just, my lord, entered.
What purpose will be served that by entering into that you cannot participate in the business?
Because, my lord, they are, my lord, registered me not to carry on the business. But I have a free access on the basis of the trial court order. And now, my lord, I have, my lord, given, my lord, this civil court, my lord, just to carry on my smooth, my lord, carry on the business.
You have filed a civil suit?
My lord. Where? Just only for the carry on my smooth running of business, and also, my lord, the cancellation of the deed of partnership. That is the main thing.
Now, my lord, even if, my lord, we did not appear in the, my lord, writ court, my lord, what happened, my lord? This writ petition was taken up, my lord, on 27th March. On that very date, we got the service of the writ petition from the postal authority. My client could not engage an advocate in that short period of time. He could not appear. Now, my lord, what happened? Even if, my lord, I did not, my lord, appear,
You could have immediately filed a recalling application.
yes, that should have been done. But the police has, my lord, filed a report before the learned single judge, and learned single judge has taken cognizance of the same, that 70-30, my lord, partnership there, 70-30 ratio is there. Now, my lord, he says, my lord, his client is this proprietorship. My lord, in that kind of a dispute, whether, my lord, the learned single judge was justified, my lord, in directing the police to help him to enter. My lord, that is my.
That is because you were disturbing.
You were disturbing. He says that I'm the proprietor now. Now, my lord, my point is, she is no one.
She claims to be the proprietor.
Proprietor.
There is a partnership.
Partnership, registered.
So for cancellation of the deed for XYZ reason, he has approached the civil court.
No, my lord, no document shown to you.
That's very good.
We
Now,
have filed caveat
today,
before the trial court.
But
no,
today, how does this order
affect
you?
Affect me is police
Partnership
is
deed, partnership
yes,
deed only.
yes. Let this part of the order will not be set aside. Police will
show us that you have invested anything in the business. You are
yes, that is there in the business, my capital, how it will be shared, everything.
So that is your partnership deed.
What's that you put in the money?
Kindly see, my lord, everything is there. My lord, kindly see, my lord, the deed.
Not the deed, Mr. Bhattacharya.
My lord.
What's that you put in the money? Deed can say a whole lot of things.
Page 10, para 5.
78 lakhs.
Page 10, para 5.
No, come to the deed.
Yes, page 10, para 5. Yes.
Para.
Six also.
So show us that you invested. Show us this, that 78 lakhs you have invested.
That immediately I do not have, but I can bring that document.
Mr. Bhattacharya, then we don't find wrong in the order.
No, wrong in the order is, below police. Problem is now police is taking the upper hand. That is the whole difficulty.
We will further direct the police authority. Because it is dispute between you two. We will reaffirm the order if you so desire. But unless you show any document in creating in a right in favor 7 except this partnership deed, which is 2023, which has been challenged and suit has been filed.
So that is no document is there, Millard. Millard, I'm sure, Millard, my trial court advocate in the trial court who is instructing me has checked up. There is nothing. We have also filed, nothing. Let them show the plate. Let them show the plate. Millard, we have filed. That's why we have filed caveat, no notice served.
Notice will be served.
Very good, Mr. Bhattacharya. You show us that any document to show that today the document which is produced by him, scale is in his favor. Because you don't have any document to establish your.
These documents were not part of the record in the trial court also.
Your conduct, you should have immediately gone back to the court. In your absence, it was done. Present appeal has been preferred. Challenging, order dated এগুলো ধরে নিয়ে আর কি। দিও না।
করবো না।
Yes.
আমার তো মনে হচ্ছে
ওটার জন্য হয়তো my lord, item number 6 and my lord, item number 12, my lord, 13, my lord. Learned Advocate General requested your lordship that these two matter may be taken up, my lord, any day, my lord, next week.
Yesterday also the letter matter appeared. Nobody appeared on your behalf. Yesterday this matter was there.
No, my lord,
This is
matter
that-
was 30, item number.
Custodial torture.
Item
Custodial
number, item number 12, yesterday that was item number 30, my lord. I don't think court.
কবে হয়েছিল? কবে একদিন শুনলাম?
No, no, I was good enough.
We
Probably,
heard the
my lord,
Advocate
in
General
a
one.
clinical establishment matter, my lord.
No, we heard the Advocate General.
Yes, my lord. My lord was pleased to direct Mr. Advocate General that
Achha, what
a
are
copy
those
of
two
FIR.
Same matter.
Same matter, my
Arising
lord.
out of
There is some link, my lord.
That 3 students were taken up. That
They are
matter.
different students, my lord.
Oh.
In that item number 2, my lord, 3 are
Arising out of same incident to
not
different
same
FIR.
incident, my lord. Here, my lord, a student before respondent, my lord. But that matter, item number 12, my lord. ঠিক আছে, 13. In item number 13, my lord, those are 3 not student, my lord, outsider.
In this case also the FIR has been registered.
No, my lord.
In the other one it has been done.
Yes, my lord.
But FIR has been registered in my case also.
In your case also. You,
Yes, my
you
lord.
have got the
Yes,
copy.
my lord.
Yes, ma'am. Not today.
So you tell us when we will take it up.
Any day, my lord, and next week, my lord.
তাহলে ওই 9 আর 13 দুটোকে একসাথে করে দিও।
No.
6 আর 13. 13 also, who is
But
the
this,
writ petitioner in 13? The appellant in 13 is here.
my lord,
Oh, you are the
yes, my lord.
Somebody else appeared now.
My lord, Jointo Narayan Chatterjee, my lord. I will inform. my lord.
Joint
এটাকে ওই অ্যাপ্লিকেশন হেডে দুটো দিয়ে দেবেন। কবে
But except 23rd and 20.
25th তো বুধবার হেভিয়াস কর্পাস আছে। আচ্ছা
Let it be on 26th.
হ্যাঁ দিয়ে দাও 26 তারিখ। 26 অসুবিধা হবে?
26.
26th, yes.
26th.
Yes.
By the RTI, balancing the direction dated 6 May, wherein a direction has been passed upon Reserve Bank of India to conduct into take a thorough conduct in the affairs of the private respondent and thereafter pass a recent order, the first part. The second part is that of that conduct the inquiry into the loss suffered by petitioner on account of the fraud, fake account that matter. In the meantime, my lord, yesterday we were served with an appeal passed by the Reserve Bank,
Axis Bank.
which is also appearing as item number 12 of today's list.
Well, I am appealing for Axis Bank. Well, item number 12 can be taken up along with 7.
Lord, this is that matter, Lordship may recall.
22 crores.
Yeah, 22 crores. As far as the Reserve Bank is concerned, Reserve Bank's appeal.
Their appeal is restricted to the fact they say we are not the authority to cause the inspection or the investigation, and we don't have the.
That's what that type of it. And your Lordship observation was that at this stage we are not interfering with the order. Whatever reporting one can be passed, you passed it. Now, in the meantime, some development has taken place. Mr. Mitro has preferred an appeal. I think Mr. Mitro's client has preferred an appeal, Axis Bank. The principal objection with regard to maintainability. The point of maintainability was taken before the REIT code also. The REIT code has considered and held that REIT is maintainable. Whatever it is, my lord has to consider that point of maintainability. I also agree, my lord, that point requires to be considered by your lordship in the appeal of Mr. Mitro. Now, my lord, so far as RBI is concerned, ma'am is giving a suggestion, my lord, subject to your lordship's. Also, until and unless this appeal is completely heard and disposed of. Because Mr. Mitro's client is the main appeal with regard to maintainability of the REIT.
Well, I'm,
Apart from
well,
other points.
may I? Well, this is, well, I'm appearing of Axis Bank. Well, the only prayer, and I say that without any fear of contradiction, only prayer in the writ petition was payment of compensation against my client. In a writ petition, payment of compensation from my client is the only prayer. So, my lord, I took 3 points. First is, this writ is not maintainable against Axis Bank. It's a commercial bank. There are judgments of the Supreme Court and there are numerous judgments of this honorable court saying that commercial bank, the writ petition doesn't lie against commercial bank. That was my first point. Second point was this, that insofar as the claim for compensation is concerned, it's a disputed question of facts. One will have to lead evidence. One will have to call witnesses. Well, this cannot be done in a writ petition. That was my second point, because that is the only prayer against my client. And my third contention was this, the thing had taken place long time back. If you file a suit today for recovery of the amount of compensation, it will be barred by limitation. So all 3 points I had taken, and my lord, it has been specifically recorded in the judgment. But unfortunately, my lord, the learned judge, in spite of it, had directed, my lord, my client to pay 20 lakhs. Right? 25 lakhs on account of by way of cost. I don't know why, my lord. I most probably, my lord, somehow the learned judge got annoyed. So, my lord, 25 lakhs of rupees costs has been imposed against a party against whom the writ petition is not maintainable. Secondly, my lord, it has been directed the Reserve Bank of India to go into the matter. I don't know whether Reserve Bank of India has got the wherewithals to go into the matter, to take evidence and all that.
It is not a question of taking evidence.
Compensation against my client be ascertained, my lord.
All these 3 points.
We filed the appeal filed.
And
Is your appeal within the time?
Yes,
within time.
Yes, yes.
And ওইটা point কোন point?
কনভিকশন হয় সেটাও বলেছিলেন রেকর্ড করেছে
submit.
Learned advocate and record for the petitioner may be in a position to indicate as to whether there is any other document left.
There are some documents left out. That is what I'm going to submit. My lord, I don't think any affidavit is required to be filed in this matter. In order to prevent the, my lord, the delay in the hearing of the appeal. Let the papers used before the learned trial court, my lord, be prepared in a informal paper book. Lordship can fix a date for hearing of the appeal because of this point to be only considered by your lordship, which according to me the learned judge has considered at
That
length.
is why we are wanting to know whether all the documents are on record.
Not in record. Not in record.
Then you want to bring further documents?
No, not further document. That is what I'm suggesting. All the records, documents relied before the learned trial judge should be before your lordship by way of a informal paper book. Informal paper book.
petition opposition reply তাছাড়া কি
জানি অনেকগুলো ডকুমেন্ট দেওয়া নেই
মানে সেটা আমার অ্যাকাউন্টে
না আরবিআই এর অ্যাফিডেভিট আছে আপনারটাতে আপনার অ্যাফিডেভিট
একটা কনসলিডেট
সেটা কনসলিডেট করতে হবে
তাহলে আমাদের একজন
and my lord lordship can fix up a date. In the meantime I would request your lordship not to interfere with the order so far as RBI is concerned, because that will not come to finality. RBI has already, my lord, held a committee, formed a committee. They have already intimated to us. So, my lord, let that committee go into that. Whatever they want to say, let them say. But that will not be, my lord.
No, Mr. Dotto, problem is there is a maintainability issue.
But not to, lordship is not giving any effect
What we
to
are
that.
minded, what we are
Maintainability of what? Maintainability as far as respondent number 11 is concerned.
Yes.
Not the maintainability with regard to RBI. So RBI is bound by that order.
Then we have to stay the order of cost, Mr. Mitno.
Cost. My lord, cost is the discretion of the court. I am not, my lord, coming into lordship can stop it today for the time being till the disposal of the appeal. But let the Reserve Bank, my lord.
No, why do we stop? If we find Mr. Mitro is not in those the judgments which are being cited, Mr. Mitro.
I have also cited a number of judgments. The learned trial judge has relied on the several judgments and ultimately come to the finding. Only, my lord. Page number বল
Compilation, one single compilation enclosing all documents.
Very well.
If that can be
I
done.
can take the responsibility of my lord on behalf of all.
Very good then. If you enclose all the documents which are relied and file a compilation within a particular time, we fix up the appeal and finish it off.
Yes,
my lord, that is what I also, my lord.
My respectful submission also.
Yes, I agree with that. That is no problem. In fact, I had also suggested that. But only one thing.
About you.
RBI is concerned, there is a direction order. There is a twofold direction coupled with a liberty. The first direction coupled with the liberty has already been exhausted during the course of the writ proceeding.
What liberty?
Please come to page 37.
No, suppose we fix up a date and invite a joint paper book in the matter.
And in the meantime, let the entire order be stayed.
No,
We are not staying the order, Mr. Mitro, because cause he is not insisting upon.
Yes.
Yes.
Your problem is
Yes,
over.
the-
So far as committee has been constituted, that we will hear out the appeal and finish it
the
off.
very
Once it is stayed, then the
No, my
entire
lord, kindly
thing
don't
goes in.
stay, kindly. My lord, if your lordships kindly come to page 37 once of the appeal of the RBI.
We are fixing up a date of appeal. You prepared a compilation, you shared with your friends. We are fixing up a date. We will hear out the entire matter on the basis of the compilation.
কতদিন সময় নেবে compile করতে? My lord, lordship give me 15 days time. I will do everything. নাও না 15 দিন সময় নাও ভাই, এই কম তখন আবার এসে এক্সটেনশন চাইবে তার
টাকা
থেকে
দিতে হবে
15 দিন।
কেউ কারো টাকা দিতে হবে পাগল না মাথা খারাপ
ঠিক আছে, এটাই
and stay the operation of the order
No,
which
my-
so far
need
as
not,
cost is
need not.
concerned.
Because as far as the
25 lakhs of rupees I am not
my-
going to pay. I'm
Have
telling
you
you
filed
very
any
frankly.
contempt application?
No. My lord, record that I am not going to file any contempt application.
No, it's not a question
My
of
lord,
that.
kindly record that.
Your
Your stay has got a different meaning. My lord, kindly not do that.
Your
I
lordship,
am saying that I am not insisting. I am not insisting for the cost right now. I am not insisting for the cost right now.
No, I am not going to depend upon the charity of my learned
I
friend.
am not doing any
I am not.
charity.
No, I am not going to depend upon charity of
I
my
am
learned friend. I am
recording.
not going to insist on
I
this.
am
What kind
recording.
of an order is this? Kindly may not come to page 38.
My lord, I am recording my submissions
No
that
order.
I am not
Mr.
going to.
Mitro, we are
A person against whom my lord writ doesn't lie,
That is
he is to
according to
pay
you.
25 lakhs of.
That is according to you.
No, I am going to satisfy here and
I
now.
can also satisfy, and I have satisfied
No,
the
no.
learned trial judge.
Learned judge wrongly has held
That
it.
is up to you. That is wrongly.
His
We have-
Supreme
Mr.
Calcutta-
Mitro, how will you be affected if we
Yes.
fix up a date of hearing?
No.
Contempt is not
I don't
proceeded.
mind that. But
Yes.
then again, my lord, the portion of this order by which I have been directed to pay 25 lakhs
We
of.
will struck it down. We
Yes.
will struck it down.
No, but then again, in the meantime,
No,
the
I am not insisting.
No,
Right?
it is not a question of
This-
my
this-
learned
this-
friend, it is a
He
question
is
of
not.
your lordship passing.
It will be our recording.
Yes, your order.
We will record
Your
that,
lordship's order.
that they will not proceed in contempt.
Absolutely. That's exactly what I am saying.
I am
Your
also
lordship
saying
will please to pass the order. I shall abide by it. Not my lord on the charity of my learned friend's clients.
Stay হবেই না। For the time being, of course.
What is the direction?
Was a thorough inquiry to be made as regards the latches or negligence.
How can that be done? I don't-
That is possible under the Banking Regulation Act. Yeah, that is
Not
according
do
to
that,
you.
we will at least we can consider that, Mr. Mojumdar. If we record that he is not proceeding in contempt, how you will be in problem?
বলে যশোরকে বলেছি।
Yes, Ashok. Both the
Kindly see para 78. On account of latches and negligence on the part.
Anyway, that is
in a
not
writ
being
petition,
implemented now.
in a writ petition, the learned judge is holding that there is a latches negligence on my part.
That is apparent
which
on the
will-
record.
Apparent on the
That is
record.
apparent on record.
Apparent on record.
both the appeals being MATs, অন্যটা দিয়েছো?
তার জন্য কিছু দরকার নেই।
I am for the respondent number 2.
Yes. Item number
8. I am for the respondent number 2, man. But as interim order, restoration of possession was claimed.
Who is your other side?
Only Mr. Shen was appearing. Thakur Shen.
He came to take adjournment for a week, I think.
Yes, yesterday.
Not there. Is he not there in court?
He is there, but yesterday his AOR tried to take adjournment when lordships were rising.
For a week in this matter?
In this matter on. He wanted to do the matter on Monday. That is AOR.
2 weeks could have 2 weeks.
Monday.
No, 2 weeks.
2 weeks. Yes.
I'm for the petitioner respondent.
No, the point is very short.
Just give us 2. Yes.
Not point is very short, not whether reconnection could be directed on deposit of 50%. But there is a statutory provision which allows reconnection on full payment and preference of an appeal by depositing 50%. It's in the code, which is a statutory provision. Please have a look at
What reconnection will be upon full
restoration only on full payment.
127.
Admissibility of an appeal by depositing 50%.
127.
Now please come to pages 74 and 75. I have enclosed the law.
payment. 74
of the stay application.
What is this, Mr.
But this is part of the Electricity Supply Code Regulations 2013, WBERC Electricity Supply Code Regulations, framed under section 181 of the Electricity Act.
Why didn't you take this point before the learned single judge?
Now it appears that it was taken.
Taken?
Yes.
Where?
But please come to page
From the order
52.
does not appear, Mr.
Doesn't appear. Not. And Mr. Mukherjee was there. Not.
এই পয়েন্টটা এই তুমি ডিসাইড করে দিতে সুপ্রিম কোর্টের
the supply to a person or premises immediately upon detection of theft or unauthorized use of electricity by an order by an authorized officer as mentioned in subsection 1A of section 135 of the Act. Provided that where for unauthorized use the consumer gives undertaking to pay the provisionally assessed amount as per regulation 5.1b of the regulations immediately within 48 hours, the disconnection shall not be effected up to that 48 hours.
What was the provisional amount in this case?
But in this case, the provisional bill was for an amount of rupees 196,26. 1,09,626. Provisional assessment order not challenged in the writ petition. During the pendency of the writ petition, final order of assessment was passed. The Honorable.
Now, what is the amount of final order?
Yeah, I'll just.
Final assessment order was how much?
But final assessment order was the amount of all. This was for 10435.
104, not so.
10435 at page 48.
That is 10,435.
That's the government due.
Sorry. 1,15,848.
1,15,848.
Yes. Then certain electricity charges were deductible. The amount rounded off to 1,09,626. Whatever was the provisional order was upheld.
বলছে দিতে 50%. Yes, you want to point us anything else?
But this is the only point. But we are not on merit of the case. He has not challenged the order.
Mr. Mojumdar, there is a proviso to 4.2.1. That read with the clause 6 point something you are reading.
Yes.
5.6. No?
Please come to 74 and 75. Not one is for the purpose of preferring an appeal.
That we understand, but the issue, the purpose of yours is to get the amount either in lump sum or by installment. So installment provision is also there. 48.
Not if your lordship kindly takes not page.
You relied upon this
6.3.
6.3, yes. Supply of electricity.
But that's a special circumstance visualized. It comes under the heading of disconnection on account of theft or unauthorized use. Once a disconnection is effected for this cause, then a consumer has a right to prefer an appeal. He can prefer an appeal by depositing 50% of the so-called assessed amount, but for reconnection, he has to pay the entire charges, which is of course subject to the appeal.
My lord, kindly see the order. Order is 50% to make payment and restoration. That is the order. And after that, directed to prefer an appeal within a month. This is the order we have received. My lord, kindly see section 127, 26 and 27.
Electricity Act down.
Assessment.
Just.
And 27 is the appeal. So both the matter in this matter no value. I have to pay entire amount.
No, we didn't follow. What is your argument?
126.
Yeah, just. আনিয়ে রাখো না
Electricity.
ওরা দিয়েছে সান্নাল দিয়েছে
Ignore the Marginal handwritings.
নিয়ে রাখো একটু 2 সেকেন্ড লাগে তো একটু ফটো তুলে পাঠিয়ে দেবো। (126) yes.
Assessment. 127 is the appeal. Then two section introduced by the legislator has no value in this case. I have to pay entire amount. I will not get any chance to challenge their action. Appellate authority will be tested whether I have committed theft or not.
But that is the provision of the statute, Mr. Haldar.
But my lord has right to pass an order. When my lord Chakraborty was single bench passes several order to pay 50%. So,
Yeah, what is it?
so this order, I think,
No,
is
how
the
do
right
you-
order.
No, he's arguing a point. No?
Yes.
What is your controversion of the issue? Statute says that reconnection only upon full payment.
Full payment, but there is
No,
126 assessment, 127 appeal, no value, my lord. That is the whole question.
Value?
There is no value.
Why?
Why? Because if I pay entire
You
amount,
have to challenge 126, 127, Mr. Haldar.
Challenge the validity of the act of these two provisions.
That you are being deprived. You are being deprived because you are right. Suppose ultimately in the statutory appeal, it is assessment order is set aside. Then in that event, you will be suffering prejudice because you will be getting that amount after disposal of the appeal. But come up with an answer, meet with the argument. We have to say something, no?
my lord, kindly, their argument is you have to pay entire amount in order to restoration. Or see,
That is what the regulations say.
that I know.
So you show us any sort of any judgment or any precedent on the issue that in spite of the statutory provisions, court can, in exercise of discretion, overcome the rigors of the statutory. Show us.
Let it be on Monday, not today.
Have you filed contempt?
No, I have not filed it.
Also, the present appeal has been preferred, challenging an order order.
Page 40.
Whereas
We have there.
then you went to the bank.
Yes. We submitted all this.
Where's the receipt? You
Receipt,
submitted bank.
they
must
have
give you a
not.
receipt.
This is, what is the demand, Malal Kalisi?
Salary account.
If salary account, everything, Malal, with reference to above and your letter dated 27/1/24, this to inform you that in order to finalize or take decision in this matter, more information will be required as type of loan, salary account details. We have submitted that.
Show us that any document you have that you responded to this letter.
Yes,
1st of February.
Malal, kindly see the paragraph J
that
of
you
the page
went
4.
on 4th of February and
I went there. I submitted. And we have stated in the writ petition also, I am the holder of account in the said branch, Malal.
Post চাপানোর কি আছে? ও মামলা করেছে ও পুরো কোর্ট থেকে বেরোতে কিস্তিতে টাকাটা এই সব ডিটেলস What's the statement? Which paragraph? You have said. Which paragraph in writ petition?
That is only writ petition with me.
You are wanting loan, you don't have the documents also.
We'll produce everything, my lord, on that we went to the branch also. Let them reject it, but consider my application. We have stated it. And similar circumstances. I want to know the result of this application, nothing more. They can reject my application. Similar circle, Milo Justice Sinha passes order. Now this matter, cost. Milo, can you see the order? That we got this information, nothing. In this matter also. Sir. Bank database we have served.
Who is State Bank? Who appears for State Bank? আসছে না কেন সাধারণত তো চলে আসে
We have served, madam.
আবার contempt বলেছি আমরা টাইম নেই এই করবে না কত সেটাই who appeared on the
I tried to serve him also. He refused. Then I went to the law cell, 10th floor of State Bank. They have not accepted because law cell is not a party. Thereafter, I sent to the bank branch and the head office.
they have received it.
Yes, yes. All received.
If you can bring him, we can dispose of because only cost removal will not help you. Your loan application will never be considered.
That is my question. That is my prayer also. Consider it.
Consider what?
The loan application.
For that documents are required. It is a
I'll submit, already submitted. If required, I'll again try to sub. Thereafter, consider that and reject it, my lord. I can bring the other side also. Who appear for the trial.
He has refused to accept.
That is the whole difficulty.
Then how can you bring him? যেটা পারে না, আমরা তো সেটা দিয়ে দিচ্ছি।
Application be considered upon hearing, and if they are not satisfied, reject it. Well, I know the fate of it.
হিয়ারিং রিকোয়ার্ড এটা থাকলে করে দিতে পারতো ব্যাংকের কেউ থাকলে করে দিতে পারতো ক্যান ইউ ব্রিং দি ব্যাংকস অ্যাডভোকেট
You are appearing. I'll try my level best.
ওরে বাবা
What happened on 10th of June?
Mala?
10th June, what happened? Matter was relisted on 10th of June for ensuring compliance. What happened?
2 lakhs. Amount
no,
is
order impugned matter was returnable on 10th June. What happened on that date?
that day said appeal is pending, some time is staying.
Who appeared for the bank?
Nobody.
Nobody?
No, yes, appeared. I don't know his name. I appeared. But I want to serve him, but he refused to accept it. And law cell, I tried.
Receive করেছে কবে দেখি we heard the matter earlier.
No. Earlier it was
13/6 item delivered 16/6 আছে কত নারিমান পয়েন্ট নারিমান
bank be directed to consider my
16/6
application.
when is the matter directed to appear before
10 days. Single bench, 10 days after. It will be heard tomorrow or day after tomorrow.
Oh,
10th of June was কালকে
so that order be at least stay. Poor man getting not loan, and there is a award for cost.
the present appeal has been
Stay of the operation of the order up to 15.
Up to 15 July, you serve it and it will appear কবে বলেছি?
14 July.
হ্যাঁ? 14th না তো, করে দাও। On 10th July.
Mal.
It will appear on 10th July.
Mal.
May it please your lordships on it. Beg to appear on behalf of the appellant, my lord. There is an application seeking leave, my lord, to prefer the appeal because the appellants here in my lord, they were not being implemented as party respondents. But I'll run very briefly, my lord,
For my
through the
lord,
facts of the case, my
before
lord.
my lord starts, my lord, it's a petition for, my lord, they've prayed leave to file the appeal. Kindly permit us to use affidavits, my lord,
My lord,
because
here's
I'll
me first, my
indicate,
lord. My
I'll
lord, here's
indicate,
me first, my lord. Thereafter, my lord, it's a case of, my lord,
because I'm challenging
case
the
of
maintainability also, because
this is
they
a
don't
case of-
have
this is
any
a case
right
of fraud, my lord, which
to
has been
file
perpetrated
this
on the
appeal
honorable
at
court, my
all.
lord. This is a case
I'll
of
indicate
fraud,
whatever
my
is
lord.
being submitted is
But
not
let me open
factually
my
right,
case.
but then kindly
Let
instead of
me open my case, my
instead
lord.
of hearing, Lord, if I may file an affidavit.
Let him.
Let me open my case. But on the basis of my letters, now this pertains to a pond in an area in Rajarhat known as Rekjoani, where there is a pond, my lord, a national water body, which is around 5 bighas, my lord. Now this was being filled up. Attempts were made, my lord, to fill it up. Now, my lord, the local inhabitants, my lord, of this area, being represented by, my lord, the appellant herein, who also is a local inhabitant. Now, they, my lord, address letters to various authorities, my lord, and on the basis of such letter, my lord, the Honorable National Green Tribunal, my lord, suo motu registered a case. Now, on the basis of that, my lord, will find
Letter. Whose letter?
on the basis of,
your
my lord,
letter.
the appellant's letter, my letter, my lord.
Acha.
Now, initially, order was passed on the 16th of April 2025, whereby, my lord, the learned tribunal, my lord, was pleased to constitute a fact-finding committee, which was to be, my lord, headed by the district magistrate of the district and, my lord, member of the a senior scientist, my lord, from the West Bengal Pollution Control Board. Now, the fact-finding committee was directed to, my lord, submit their report on the 19th of May 2025. Now, on the returnable date, the fact-finding committee said that we have done the inquiry, the physical inquiry. We will require some more time to file our report. Now, on that day, my lord, 19/5/2025, the writ petitioner respondents here in, my lord, they filed an impleadment application before the, my lord, learned tribunal.
What application?
An impleadment application, an IA. So, my lord, they stated the facts there and
Who filed?
the writ petitioner respondents, my lord.
That is Ambud.
Ambud, my lord.
1 to 18. Respondent
So
number.
they filed, my lord, this impleadment application. They said that we want to be heard. That was also recorded, my lord, and the next date was then accordingly fixed on, my lord, the 11th of July 2025. Now, my lord, this happened on the 19th of May. Now, on the 20th of May, the same, my lord, interveners, my lord, before the National Green Tribunal, as writ petitioners, my lord, they moved the writ petition before the Honorable Single Judge in a police inaction matter, my lord, under the police inaction determination, stating that we have addressed a letter to the police. We were filling up a pond pursuant to the conversion permitted to us, but there were obstructions. Now the police is not rendering assistance. We have also approached the executive magistrate. There is an order by the executive magistrate. Despite that, we are being prevented. Now there was not a single whisper, my lord, made.
Disclosing the NGT.
Yes, there was. But there
Without
was.
disclosing the NGT proceeding.
Yes, not disclosing. Not even a single.
Without disclosing.
Without disclosing, my lord. Without disclosing. My lord, the law in this aspect is very clear, my lord. But that, my lord, parties are not permitted to pursue parallel proceedings. Where there is a remedy available, and in fact, where the party has approached such, my lord, jurisdictional tribunal, this is one, my lord. They suppress such fact and approach, my lord, the Honorable High Court, issuing high prerogative, my lord, in exercise of high prerogative.
How did you know that they have suppressed writ petition was?
No, writ petition I have obtained from Sharthok, my lord, now. Because our knowledge, my lord, we gathered knowledge because, my lord, there was once again an attempt to fill up the pond. A part of it has also been filled up now. We have annexed photographs also. Then, my lord, the local inhabitants.
He did not pass any interim order in your favor?
No, but the orders are there, my lord.
No.
The orders are there, my lord. My lord will find. My lord, kindly take pages 33, which is the first order of the stay application, my lord. My lord, kindly takes pain, my lord, to come to Annexure B.
So construction is on.
But the pond is being filled up, my lord, the water body. And my lord, the law, the Honorable Supreme Court of India also, my lord, back in 2012 has made it amply clear that where, my lord, the issue pertains to environmental matter, the parties have to approach, my lord, the NGT first, my lord. I am carrying that decision also, my lord. So there are three grounds on which, my lord, but I am assailing the order passed by the Honorable Single Judge. First is, my lord, suppression of facts, my lord, because, my lord, an Honorable Single Judge, the Honorable Judges are supposed to know the law, not the facts. Here it is not a case of twisted facts, my lord, being represented before the Honorable Court. It is a case of, my lord, a diabolic fraud. 19th of May, they move an application before the, my lord, Learned National Green Tribunal. 20th of May, they move parallel proceedings without a single whisper. So this is one. The second is, my lord, parallel proceedings, my lord. The London National Green Tribunal is already in session over the issue. They have done it deliberately, my lord, to render the proceedings
What is the
infructuous.
present state?
My lord, it has been posted, my lord, on the 11th of July, because, my lord, the state.
Very good. Now, what is happening at the
My
site?
lord, at the site, my lord, I have annexed photographs. You, my lord, kindly takes, my lord, the fourth volume, my lord.
Who was the last NGT order? Where
Yes, the last NGT order, my lord, will find at page 37.
Come back at 2 p.m.
Very good.
Sir, may I come back tomorrow instead of today? 2
My
o'clock
lord,
is a
there is
fixed matter, my lord, that's the reason.
some element of urgency. I leave the rest to your lordships, my
I
lord.
can come back tomorrow, my lord, anytime.
The water body, my lord, that is being filled up partially,
I'll
also filled
indicate
up.
whatever is being submitted, I'll indicate from the documents how erroneous the submission is. I'll indicate that.
That is being,
Once
that
the
was being
learned
adjudicated by the honorable, by the
There is
learned
no
NGT.
order from the NGT, my lord. No
What was
order
the
at all.
first
You
question?
have problem.
My lord,
2 p.m. you have
the
problem.
matter fixed, my lord, where I'm arguing, my lord. Only this. May I come back tomorrow anytime, my lord?
এটাকে অ্যাপ্লিকেশনে প্রথমে রেখে দিও।
কালকে আমার কি আছে?
হ্যাঁ?
কালকে তো ইয়ে।
কালকে রেসিডুয়ারি।
Oh.
Tomorrow?
But, tomorrow, my lord, will it be, my lord, pleasure, my lord, to take it up at 2, my lord? I have a matter already fixed, my lord, at Gangtok High Court, my lord, which I'll be doing virtually from here at 10:30.
Let it remain in the list. If you are in problem, we will adjourn it.
Or, my lord, may I, my lord, conclude my submissions, my lord, at 2, my lord? I am ready, my lord.
My lord,
I am ready, my lord. This is the case, my lord.
Order both of you and
Indeed,
pass the
indeed,
order.
my lord. I'm very grateful.
আচ্ছা কালকে tomorrow 2 p.m. কিছু ফিক্স আছে? আচ্ছা tomorrow
Extremely
tomorrow
grateful.
2 p.m.
Extremely grateful.
tomorrow 2 p.m. you
My lord.
Extremely grateful.
My lord, under circumstance, I know, my lord. this is
What,
not the
what?
right time for it. Item 13, it has already been fixed on 26 June, my lord. You are not there, my lord. On 26 June, I have some personal difficulty, my lord. I have to attend a hearing for human rights.
no, which matter yours?
13, my lord.
Oh, that
Here, my lord, in our absence, that has been fixed, my lord. 26th, we have some difficulty, my lord. My lord, can
so
you-
Mr. Chatterjee, that he's junior.
Advocate General Junior, I shall inform my lord.
Shumita. আমি নাম্বার দিয়ে দেবো
Right,
সুবিধা।
you on we have kept it when
26th,
26. Acha, please ask your junior to remind us.
on 26th.
26, let somebody be here and you in the meantime inform them the 26th you have mentioned in problem, then we will keep it on the next date or
But may I file the affidavit of service also, my lord?
kalke di
It is always a privilege to address your lordship, my lord. It's an added privilege, my lord, to address my lord Justice Mitra for the first time.
Who came the other day?
No, that was mentioning.
I appear for the respondent number 1 writ petitioner, or I am praying for not this week, my lord. Only not this week.
State is the appellant. My learned friends will be respondent.
Tomorrow, sir, I have some personal difficulty, my lord, on Monday.
Next Thursday.
Sure.
Grateful.
কিন্তু কেউ করবে না। এটা আমি মেনে দিয়েছি, দিয়ে যাবে। কেউ করবে না।
14 নম্বরটা অপোজিশন কতগুলো ফাইল করতে হবে? 15 my lord, it is the appellant, but the respondent writ petitioner had filed one interlocutory application to which the state has filed an opposition. They have not yet given a reply to thereto. So may I respectfully, my lord, file the opposition filed by the state lordship. My lord, opposition is out of time, my lord.
You have filed opposition to their application can too.
Lordship. Lordship.
No one appears today on behalf of the appellants.
May it please your lordship's my lord, beg to appear on behalf of the appellants, my lord.
Is your other side?
My lord, Mr. Mr. Orijit Chakraborty, my lord, was appearing on behalf of the ED. Here, my lord, we have filed an application. Now, what happened is, my lord, the predicate offense, which gave rise, my lord, to the ECIR to be registered by the ED. Now, that predicate offense has ended in, my lord, filing of a police report, my lord, whereby it has been found that.
Yes.
It is on the way. Let them start. I will take the note.
My lord, here, my lord, the predicate offense is no more existent. A closure report has been already filed. And my lord, on the basis thereof, my lord, the law as on date, my lord, is, my lord, that once the predicate offense goes, the ECIR cannot remain. So this is the limited extent to which, my lord, we have filed the application now, my lord, which is can 2, my lord.
They have used any opposition?
They have filed their affidavit, my lord.
You have filed your
Yes, yes. Pleadings are complete, my lord.
I see.
Pleadings are complete.
কি বলবেন এবার? Your counsel would be coming. Who is appearing?
Arijit Chakraborty.
But Mr. Chakraborty is appearing, my lord. I don't think, are you sure he will be coming? Because he said that you will be coming and praying for an accommodation. Mr. Chakraborty called me yesterday night. He said that my junior will be coming and praying for an accommodation. She has just joined, so do not be.
Should come next Thursday. Yes, next.
No, but I said that my instructions are that I have to oppose. So I'm formally opposing the prayer.
Yes,
He
next.
said he is coming. That's why I'm going up. You will start, I will take you.
Both 16 and 17.
By 16 and
16 and 17. Yes. আমি সকালেও কথা ও যা ওরও তো ওই অবস্থা বলছি কেন এটা
And one is application for stay and can two is for leave to appeal. Challenging the order dated stage 12.
Yes, what are you saying? You are for whom?
But I am basically supporting the appellant, my lord.
Who is the
He is my son, my lord. He has not made party in the writ petition. He is the owner of the premises.
who is appearing for electricity?
I am appearing for.
You are appearing. All right, let us see what is the order. Who is for 4 and 5?
Appellant is the owner, my lord.
Appellant is Prosenjit Chandra. Only one person appellant.
Yes.
Only you have come.
Meter room is situated inside.
Yeah,
my-
yeah. You are not a, you are not, you are, in the writ petition, you are not a party.
Yes, ma'am.
You are not a party in the writ petition.
Yes.
You are, this is a leave to appeal.
Yes, yes. Sir.
Oh, I see.
You are the son.
Yes, I have.
What is your relation with the writ petitioner Sandeep?
But
You are Sandeep.
No, my lord.
You are, who are you?
I am the father of the appellant, my lord. I was made party in the writ petition, though I am not the owner of the premises, my lord.
You are.
My son is the owner of the premises.
Uttam. You are Uttam.
Madan, my lord.
Respondent number 4 in the writ petition.
This one 5, my lord.
Respondent number 4 in the writ petition.
So you are Madan. Your son is this Sandeep.
Yes, my lord.
Sandeep is your son.
Yes. He was not made party.
He was not made
Made
party,
party.
but you were party.
Yes.
Who has not been Indian party? Sorry, proceed.
সন্দীপ বলছো তো। সন্দীপ তো কেস করেছিল আমি তো কেস করেছি তুমি তো সন্দীপ বলছো জোসেফ জিজ্ঞেস করছো তুমি শরণ বলে দিচ্ছ
Yes, what is your objection?
My lord, I am the owner of the property. Without making me party, how
All
CSC?
right, we are making you party. You tell us how, why you are standing. Then who is for Sandeep? Sandeep, nobody is appearing.
No, my lord.
Yes. He is the writ petitioner.
Yes, he
na?
has not appeared. Last occasion also he is not appeared.
My lord, all in complaints of the my lord single bench order. My lord, it writ petitions order. My lord.
Pardon?
We have in
Connection has been affected.
My lord,
Connection effective.
connection has been affected. And 15 May, my lord, order was passed by the learned single bench, my lord. There are 24/4/2025. And within stipulated time, as per the order of the learned single bench, my lord, we have complied the my lord said order and installed the meter within stipulated time in the said common meter position.
What remains, sir?
My lord, only contention before your lordship, paragraph 3 to 6 is of the stay application.
Where does Sandeep reside?
Sandeep, my lord, there is a shop room.
Well, in the same
Shop room
premises,
belongs
same
to
holding,
Sandeep.
same premises.
Shop room belongs to Sandeep. He is running his business. He is not staying that particular area. Meter room is situated inside my dwelling house. By installing meter, the writ petitioner get
Yes, tell us what do you want to say? You have nothing to say. We'll allow your leave to appeal, we'll dispose of the.
my lord, if the CSC is directed to reinstall the meter, my lord, I shall pay the cost, my lord. There is a space at the
What is
portion of
your
the
problem? You are the father. Son is here with you.
yes, my lord, I am supporting him.
Hmm?
But there is a space where the writ petitioner is occupying, my lord, for installation of meter.
Writ petitioner is occupying the portion where the meter is there.
No, my lord.
Sorry, the shop room, the meter from which the connection has been given is lying within his property.
Yes. Inside his dwelling house.
What is the connection
lord,
given? There must be a
my lord,
separate meter.
one common holding premises, and there is one common meter room.
Pardon?
My lord, one common holding and common premises. One holding number, premise number is same, and there is one common meter room, common service positions, meter board, and in the said common service position, meter board we have installed the meter. In the common service positions,
There is no common
and
service.
there all the meters are like.
No.
If my learned friends have any clients objection, then he should have to make an application before us for shifting of the said meter. And if after my lord
finding the suitable position, and we shall give, we shall see that a suitable position is being available, then we can shift all the meters from that premises. All the meters. In two services cannot be given, my lord. In a common positions, then all the meters should be, my lord, installed there. He should make an application that for shifting of the
So
meter.
there is a common in a particular portion, all the meters pertaining to the property are situated.
Situated.
So yeah, the connection which you have given to the writ petitioner, that is through a separate meter.
A separate meter. He separate meter in the common separate meter,
In the
common meter.
portion.
Common portion.
Yes,
No,
then
my
what
lord,
is
the
the
service portion is not common, my lord. It is specifically for the appellant. It is not.
No, suppose very good, it is within your portion.
Meter
You are
room.
also getting advantage of that. You are also getting electricity
My lord,
from the meter installed at
by
the same portion.
taking advantage, he is getting free access to my dwelling house, my lord.
That is a separate case. You then lodge a police complaint. What separate access you will get? The line will be drawn from the common space.
It is not a common space, my lord. The meter room actually situated inside my dwelling house. It is not a common portion.
So inside your dwelling house, but there all the meters of all the persons
No,
are
my lord,
there.
only my meter is there. Only my meter is
In
there.
respect of this connection, no separate meter has been given.
Separate meter installed, my lord, after this order. My lord, prior to that, only my meter is there.
So from where did he get the electricity? This shop room, where did it get electricity from prior to installation of this meter?
But after getting installation of meter,
Prior to.
there was no service connection, my lord.
No connection?
No.
So how many residents are there?
But I am only residing there.
And Shondeep is the shop owner.
Shop owner.
He's a tenant under you.
No, my lord, this is ownership.
Ownership. So where from he will get the connection?
My lord, there is a.
It has to be given from the position where if the meter is installed, what prejudice you will suffer?
My lord, he is getting access to my.
How he will get access?
My lord,
Sir?
he is entering into my dwelling house frequently, my lord. He is disturbing.
Then you lodge a police complaint. Lodge a police complaint. Meter for meter reading, the CSC authorities can enter. The private person cannot take access.
My lord, there is a
Person, where is your allegation that he is entering?
There is a provision. There is a provision for installation of meter at the portion of the writ petitioner, my lord.
Do you
There
have
is
any
sufficient-
other space for
sufficient
installation of
space.
That is why, my lord, I am mentioning, I am submitting to your lordships. If, my lord, my learned friends have any objection for shifting of the meter, my lord, he can make an
How he
objection
can-
before us.
Then he has to lodge a complaint to you.
Yes, lodge a complaint to us. And thereafter, my lord, after finding a suitable positions for shifting all the meter, we can, my lord, install all the meters.
There are
Otherwise, my lord, in one service, in one premises, my lord, in one
there is only the landlord and the
and according to him,
persons.
according to him.
Two
And that is one, my lord, one holding according to him, landlord is there and my client is there. And one common meter board is there.
What common meter board?
No common. Sir, that is a service position.
Where we have installed the meter.
So this access to the meter room has to be taken through his room.
My lord, otherwise,
Then he has to apply for a shifting of
my lord,
Madam, please do not prompt. You go and sit behind.
my lord, if that be so, my lord, my instruction is that, my lord, if he would have any objection regarding, my lord,
His contention
is that inside his room,
taking access to his
inside his room, my lord,
Is
this
true?
petitioner,
Is this true?
my lord, it is true. My lord, regarding in his room, my lord, that is, I have no instruction. I have the instruction, my lord, in common meter position, which is he, as per his petition, appellant statement, my lord, that is inside his room. In that position, my lord, this meter has been installed. But according to us, my lord, without that, we have no other alternative. Because in one common premises, in one common positions, two services cannot be given. There is technically there is electrical hazards. So, my lord,
Can you fix his meter in some other place?
that we can shift it, but he can make a complaint that you should shift my meters. Then, my lord, if we can find a suitable positions, the 2 meters can be installed without any electrical hazards or technical difficulty, then that can be done.
So you ascertain that.
Then he should have to make a complaint to us that you should shift the meter, this
No,
meter on
why
other
should
meters.
why should we ask him to lodge a complaint if the problem can be resolved? If the problem
Well, only
can be
no complaint, only my lord for my lord asking us to my lord shift the said meter from that premises. And my lord, after that, my lord, we shall make an inspection, and also my lord, after finding a suitable position, we shall shift to the meters to the said premises. Because in same
owner's meter.
according to this appellant's meter as well as my lord, the petitioners, read petitioners meter. In one position, both the meters could be installed. Otherwise, that cannot be possible.
Yes, sir.
It has been
That has been served.
it has been served to Mr. Indranil Halder, learned advocate for the.
That was not a direction. Also, to you have to serve the private respondents. Who is Uttam?
Uttam is my brother, my lord. He is.
Not problem. So why you have not served upon Sondip?
It has been served upon the learned advocate.
Read the order. No, why you are unnecessarily saying? Read the order. Read order to the. Next Thursday, complete service and দিয়ে দাও ওটা ফেরত দিয়ে দাও Mr. Guchayat, in the meantime, will it be possible to find out for you that whether there is any other place?
Yes, my lord, I can
If you can take an instruction to that effect, then we will shift both the meters at that place. Yes, next.
May please,
এই যে ইলেকট্রিসিটি এখন এই মেয়েটি Yes.
My lord, your lordship may recall that installation of a gate in front of my lord, the main gate of the house. But kindly look at my lord page 57. This is an old building, and my lord, there is an auto rickshaw just in front of the auto rickshaw. We sought to, my lord, install the main gate. Gate is there for safety, my lord.
You are the writ petitioner appellant?
Yes, yes. But that the private. দেখি
একই রিপোর্ট পেজিং এডিট করা আছে, একটা পেজিং এডিট করা নেই।
Yes.
Now, my lord, the private respondents are creating nuisance. My lord, your lordship, if your lordship can take the
So
trouble.
what is this other writ petition? WPA 2.
Earlier, my lord, yeah, my lord.
You preferred.
Yes, yes. And Justice Hiranmay Bhattacharya was pleased to pass an order directing the police to, my lord, keep vigil such and such. Now, in the house, my lord, only my father, my lord, this is.
So your prayer was refused.
No, not your.
Show us that order.
Page, my lord.
Page 46 of the application.
Page 40 from the report of the Sub-Inspector of Police, Shampur Police Station, page 47, my lord. It appears pursuant to the complaint lodged by the petitioner, an inquiry was made and prosecution under section 351(2) has been submitted against the private respondents by Shampur Satan Saj. It appears that the police authorities have taken steps on the basis of the complaint lodged by the petitioner. The officer in charge, Shampur Police Station, directed to ensure no breach of peace takes place. Now, while we are, my lord, going to install the gate, they were, my lord, again obstructing and creating nuisance.
No, my lord, page number 46 of this order, my lord. Kindly have a look this page number 46 of
You
this
will
order.
get your
My-
chance. Let him finish. Yes.
Then, my lord, but on the that order was there. Then we sought to install the grill, main gate. Again, my lord, they obstructed. We made the complaint. Nothing was done. So, my lord, we approached this honorable court again. And my lord, Mr. Justice Tirthankar Ghosh was pleased to pass
So
an
in
order.
the earlier order, where what is said that you will get police protection for raising the gate?
That prayer was not there.
Then your complaint was that you are they are
Yes,
disturbing.
complaints are there. Then, my lord, again they were disturbing.
So court only said that don't see that no, there is breach of peace.
No breach of peace. Now we want to
So why didn't you make prayer at that time?
that, my lord, it was not properly represented. Now, my lord, again.
Then how can we now that writ petition appears to be pending, page 49.
No, that is not pending.
Page 49, kindly come.
This is a this is, my lord, of my lord Mr. Justice Tirthankar Ghosh. It is not pending. Pursuant to this order, my lord, final order has been passed. That is at page, my lord, 61. 61. 61. 61 to 62, state has not submitted a report as directed in the order dated June 30. However, having regard to the prayers and directions, I am of the view, same need not be gone into her disposal writ petition. All parties act. Well, only observation was made. Page 62. It has been pointed out by the learned advocate for the respondent 5 and 6 that similar prayer was advanced as your lordship was mentioned. The same was considered by coordinate bench by it order that it was directed the petitioner free to approach the appropriate forum in accordance with law. Thereafter, my lord, we approached, my lord, for police protection, police help, so that they would not create any obstruction in the installation of gate.
Yes, what is the problem, sir? You are for?
I am for the private respondent.
Why you are opposing?
Well, that is, he wants to lock my property.
No. Make it
that
clear.
that is my allegation, my lord. By this process.
How?
My lord, this
is a multi-storied building.
Yes. There is a common, my lord, the staircase. Well, he wants to lock the stair.
No. Page 57, my lord.
Before that, my lord, your lordship kindly come to my lord. Your lordship
my
last
lord,
order.
My lord, may I clarify? Page 57, in the right hand side, my lord, our line.
Come to page 50, Mr. Mustafa.
57.
Come to 50.
50?
50, 6.
Yes.
You want to put the gate here where the staircase is.
Yes.
No. It is a this is page 50, but 50, my lord, this is my premises.
No, the staircase, that is your premise.
Yes.
Staircase
It's mine.
is your premise.
Yes.
My lord, one side is his, one side is mine.
No, no, how it can be yours? That is a staircase leading to the first floor.
No, my lord, that would be clarified page 57. In the right side, my lord, there is an auto rickshaw. Just in front of the auto rickshaw, my gate. And in the left side, there, in the right side, there is an auto rickshaw who just in front of the auto rickshaw, Toto, my gate is there. My lord,
The entry to the to your portion and to their portion is separate.
no, yes, yes.
He is also a owner of any particular.
No, they are in the left side. In the one gentleman with a motorcycle, that is their side.
Not in the same building.
No, no, no.
They are not staying
No,
in
no,
the
no,
same
no, no,
building.
no. In the kindly see, my lord, in the left hand, in left side, page 57, one man is motorcycle.
You are showing us an apple and you are wanting us to believe that that has been eaten by somebody. Where from motorbike person is standing, that side.
No, that is their side. That is their side. Indicate my indication of side. In the right side. And well, why
we want to know whether you, first of all, whether you and you are residing in the same place.
No, not at all.
So in your portion where you are
residing,
are you only residing there or there are other persons?
It is me, my lord. And my lord, this is the condition of the my father.
You first show us that they are residing in a separate building.
There, my lord, in the page 57.
Where in the writ petition you have stated? You are showing us right and left, right and left.
My lord, kindly see page 45, 3 decimals of land recorded in the name of Amrita Singh.
We are not concerned on that. It appears from the photographs that there is a building. It's a house. Are you the only person staying there?
In my house, I am the only person.
So are there these persons are, according to you, residing on the opposite side?
Yes, opposite side, other building. They are not in any way connected. They are not in any way connected. They are.
Then why did you where have you stated that they are not residing at your premises?
What to my petition? My lord, paragraph 4, I have stated G plus 1, paragraph 4, that in the year 2000, G plus 1 building has been constructed on the petitioner's plot in the ground floor. There are 7 small rooms in the first floor, 3 big, but construction incomplete due to lack of money. Staircase was opened because valuable materials and valuable goods have been theft from the house because petition have been about 1 lakh. In this way, this is my portion. Local people suffering in the security. Your petitioner raised objections against unsocial work. Then the petitioner lodged complaint to the police or prayer for police protection or police at the time of setup of grill in the staircase gate, but police authorities remained silent. Our only recorded owner of the aforesaid property being plot number. And my lord,
so they are local persons who are want to enter your property.
Not enter, they're obstructing only to install the grill and creating nuisance.
Install grill where? Where you are?
In my gate, your lords, in the gate of my building.
Show us the complaint you made.
Kindly look at my lord, page 31.
It is a G+1 building.
Yes. Small building.
You are residing at the first floor and in the ground floor there are some
small
shops.
shops. Yes.
Then the portion where you are installing the grill.
In the main entrance. Main entrance. এটা তোমারটা বার করো। My lord, officer in charge, Shampur Police Station. আপনার নিকট বিনীতে নিবেদন
Please let us. তো ব্যক্তিদের কোনো মালিকানা, কোনো শরিকদারও নয়, সম্পত্তি দাগ্ন, সুতরাং আমার সম্পত্তির সহিত পেজ 32। তা সত্ত্বেও উদ্দেশ্য হইয়া যারা শান্তি শৃঙ্খলা বিঘ্নিত হইয়াছে। In view of the earlier objection, বিদ্রোহ বলে দিয়েছে
only 3 decimals of land.
তাই তো বলেছে।
My lord, page 31 in LUC it is written, উল্লেখ থাকে যে আমার সম্পত্তিতে উক্ত ব্যক্তিদের কোনো মালিকানা নাই, কোনো শরিকদারও নয়। উক্ত ব্যক্তিদের সম্পত্তি দাগ নম্বর 3360। সুতরাং আমার সম্পত্তির সহিত কোনো বিবাদ নাই। তা সত্ত্বেও অসৎ উদ্দেশ্যে লইয়া এলাকায় শান্তি ভঙ্গ করিবার খুন খারাপি অধিক টাকার দাবি করিয়া বেআইনিভাবে বাধা সৃষ্টি করিতেছে। চন্দন ডুগার, তাপস ডুগার and অরুণ ডুগার, they are the মানে private respondents. They are not in any way related. And kindly see on page 51 how the nuisance is there. Page 51. Water bottle.
Yes, all right, take your seat. Yes, tell us.
My lord, kindly see your lordship's order dated 19th May 2025 once.
19th May?
May.
আমাদের?
Yes, yes.
Our order?
Yes. Your lordship passed.
Why did we call for that?
Because of paragraph 4 just now your lordship gone through.
Paragraph 4,
page 21 of the writ petition. '21 of the stay application, sorry, lordship. Your lordship got.
Yes, yes.
Now your lordship kindly see paragraph 2 and 3 of the supplementary affidavit. Last occasion my lord filed by the petition. Kindly see paragraph 2 and 3. Which is correct? I don't understand. In 2021, he said he constructed the building. In 2021, he wrote a letter to the Pradhan for renovation work, which is correct.
Who are you?
My lord, I am the person who constructed the building in a PWD land.
Are you residing in that building?
Yes, the first floor, my lord, the ground floor, my lord.
Show us that you are.
It's a PWD land.
No, no, you show us. You are occupying any portion of the building, please show us. You are not involved in this building.
Lord,
give us any document that you are a resident of that building, because his contention is you are not a resident.
The first floor, my lord, belongs to me. But the ground.
Show us na that first floor belongs to you. You are just an outsider in the property.
No, I'm not just an outsider.
So you justify, show us that you are residing in that building. That is true. He is not a resident of your.
I am an occupier of the building on the first floor. Man, it's a PWD land, my lord, the building constructed upon the PWD land.
We are asking you to show us something that that you are residing in the building, because he has made a statement you are not a resident of that building.
My lord, because of my construction on the PWD land, the petitioner earlier filed an application before this court for demolition of the building. And my lord, the building not been demolished by the authorities, my lord, as yet. And because of that, a contempt application is pending, still pending.
So if the building is demolished, he will suffer.
Not been demolished yet. Not been demolished, my lord.
So very good. Then if in his property wants to put a gate for the safety of the building.
So this is my property. He wants a demolition of my property.
Demolition where? This case we are wanting, show us then. You are not a resident of that building.
No, I am the occupier of the first floor, the ground floor. There are several shop owners, they are in the ground floor. I am in
Nobody
the
has
first.
come before us. Nobody has come before us. Show us that you are residing in that building. Hey, who is police? You are police. Go and find out who is there in the
No,
building.
no, no, my lord. What has happened, my lord? My lord, this is the 40. My lord, kindly have a look. This 46. My lord.
Please answer our question.
My lord.
Are you sure that he is he is occupying any portion of his premises? He is a resident of that building.
No, my lord. I am not saying, my lord.
Not a resident of that building. So if in my building I want to put a gate, what is your problem?
No, my lord. That is
Simple
true, my lord.
equation. It is my property. I am occupying. I want to put a gate. Why? Because some hooligans are entering into my property and staying at night in having drinks and other things.
My lord,
This
that's
is his allegation.
My lord, that's why, my
The
lord.
family man is staying. This
Previous writ petition, my lord, same prayer
Forget
is.
about you show us. Go and see whether this person is there in occupation of the.
My lord, we have find it out. My lord, I am appearing for state. My lord, kindly come to Annexure 3 where it is showing that petitioner's building is on the PWD land. We asked the executive engineer whether that land is PWD land or petitioner's land. My lord, kindly see our report.
Where is the report?
Up to date report, my lord.
My lord, kindly.
Where did you file this report?
My lord. My lord, this report is clarified that
My lord, report dated, my lord. Kindly second page of this, my lord, 12 June 2025, my lord. This signed by the officer in charge of the Sampur police station, my lord. This is annexed all the, my lord, demarcation and, my lord, PWD reports.
Wait.
my lord, kindly come to Annexure 1 first.
Wait, madam, let us go through the report.
My lord, my lord.
You disturbing my VC conference শোনা আমার তো ভীষণ মেডিটেশন লাগে কোনটাই পড়ে পেয়েছো কতদিন পারমিশন পাইছি Possession was a 25/12/1958. এখানেই দেখছি স্যাংশনটার মধ্যে খরচ হয়। You have sold it, they have sold it to somebody else.
Hello, that is their development the story. Kindly look at page, it was a long plot, page 42. Only 3 decimals of land was relinquished in my favor. That has been recorded there, my house, page 42. There
Who is Vishwanath then? Their allegation is you have sold it to Vishwanath.
no. We have not sold. Kindly look at page 42. Relinquishment of land, such and such. Then what plot number 3359.
So you constructed the building.
Yes. Then, my lord, kindly.
Then the sanction plan has to be in your name.
My lord, it is an old house, so there was.
Don't give all these things. You show us clear documents.
Page 45. Page 45, my lord. Recorded in my name, Amrita Singh.
Mr. Mustafa, if we ask a question and we don't answer for that, don't give a different answer. We are asking you, you are the owner of the house. So when you have built the house, you must be having a sanction plan. Sanction plan must be in your name because the police report says that you have sold it to somebody else.
No, I did not say.
Buddy, you don't know what you are asking him. You see the document.
I have.
Read the document.
One second, my lord. It is a report that the collecting the sanction plan building is in question from the conclusion such and such. Learn that petitioner sold the same to one Vishwanath Bera having property situated in plot number with the number such. My lord, this is not correct. This is not correct because my lord, 1 point. Dindakola ground, Shampoo, how it is came to learn that the petitioner sold the same to one Vishwanath Bera having the property situated such and such.
If you, Mr. Mustafa, listen one thing. If he is not a person in that building, we will not allow him to interfere with the gate. But for that, we must know that you are the owner and he is not residing in your
Yes.
Where from we will know.
My lord, my lord, that's why, my lord, page 42, I am the record of rights.
Recording on the basis of recording, you can come to know that your client did not go to you. When the client showed you the record of right, did you tell him that yes, I am
Title,
satisfied?
yes, title is necessary, title. But my lord, it was.
We are talking about a building. It is a G+1 building. So if you have constructed the building, you will not know that who are the occupants. You are saying that he is not an occupant. So that fact that you are the main constructed the building, give us some documents, you satisfy us.
My lord, page 42.
We have seen all your documents. Do you have any copy or not? We dismiss the appeal.
Page.
Eating about the bush.
Yes. Page 57, my lord, is the residential building. In the right side, record. My lord, on a small 3 decimals of land, they are saying 1.1 soto.
We are not on that. We want to know whether you
Yes, on the last occasion, your lordship put us the question, the sanction plan. Sanction plan is not there, admittedly. That is question.
Then how we are to know that you have constructed the building or you are residing there? How will we know?
On oath, I have stated, my lord, we are residing. My lord, this is the condition.
Go to the civil court, establish your title.
My lord, kindly see the picture. Father is my lord.
Picture will not help.
No. That's why we want to put up a grill. Father in dying condition, my lord. So
yes, we are wanting to know, is there any document here which shows that who are the occupants of the building?
No, my lord.
Huh?
No documents.
So this is
only, my lord, at the time of measure.
So for making safety, a gate is necessary. This is the condition of my father of the petitioner. He is residing in the house.
Sir, yes, which document you?
My lord, my lord,
Question to
I want to, my lord, I want to show the document annexer 1, which is annexed in this report, where we have inquired whether this land, my lord, kindly come to the annexer, my lord.
Don't answer the query of the court. Please do not answer. We
My
are
lord.
we are wanting to know from you who is staying in that building.
The house, not building.
There is a
Who is residing?
There
Who
is a
is residing?
we are not wanting to know. We are wanting to know who are the persons in the building. He says that I am the person, and in the ground floor there are some shop owners. Whereas the private respondent says that no, I am also a resident of that building.
My lord, it is clear we come to know that he has sold the property to one Vishwajana, but
Where
we
from?
have inquired.
Which document shows that he has sold it to Vishwanath?
We inquired the local people, my lord, disinterested people, and from there we have come to know that they have sold the property, my lord. But only the question
assist us to this effect whether the private respondents are residing at that building. Only tell us.
My lord, I will inquire. Then only we have inquired PWD engineer whether that building has built upon their land or it is came under the purview of PWD land. We have inquired all these things, my lord. But who is deciding now, that we will inquire. With that report, I can produce before your lordship next day.
Heard the learned advocates appearing for the respective parties. That's no doubt. ঠিকই বলতেছি। Safety security purpose করে একটা গেট তৈরি আছে। ও ঠেলে দিতে চাইছে সিভিল। If the gate is constructed, how will you be affected?
Well, I cannot go to the upstairs.
No, you will get the keys will also be given.
But for that reason, he wants to install the gate.
What for that? If you are residing in the building and there's a main gate installed for security purpose, how will you be prejudiced?
Well, he not given the keys. He changed the.
I don't say if you
Kindly record that. I don't have any problem. Kindly record that.
problem is
Yes.
solved.
Yes. Not obstruct me.
No. We will record that you are in occupation of the first floor. It is not being yes. He knows that he is staying. You are saying yes. I will give the keys. Allow me to construct the.
My lord, kindly see, my lord.
Means he is in possession. You know.
That means you know that he is in
My lord,
possession.
they are not at all in.
Then why are you saying yes?
My lord,
You should say, I will
No,
not give him the.
for installation of gate, my lord,
So you want first let us get the gate, then we will think about the keys.
keys. My lord, no, if they have the
No, no,
legal-
Mr. Mustafa, if you say that he is not occupying that building, how you just now agreed that yes, I will hand over the.
No. For installation of gate, my lord, for safety, I have
Utterly disbelievable.
no, my lord, kindly first opening sentence, my lord, is I am the absolute recorded owner and
We are saying, why did you say that if construction he will get the keys? If he is not an occupant of the building, why will you give the keys to him?
my lord, I said yes for installation of the gate. They are in a separate building, my lord. They, my lord, how I cannot allow them
Your
to
Lordship,
enter
kindly
in my.
see a retweet copy of the retweet and the prayers. Not in this proceedings, the earlier proceedings filed by the petitioner for demolition of my building. Kindly see the prayers. Here, my lord, the prayer is to demolish my building, which obstruct, my lord, his ingress and regress. But kindly see the orders passed in the writ petition. His admission that the building is constructed in front of his, my lord, the plot.
That is your building.
Yes.
So
that
that
building
indicates
now
you
he
are
wants to-
separate.
In respect of the same building.
Sales and buildings, he wants to, my lord, put the grill gate and kindly see the order, my lord. Lord, I am sorry, my lord, only one copy is there.
Thank God it's one copy.
Order of Justice Bhattacharya.
No.
By Jagadish Chandra Singh.
My lord, father of the writ petitioner. Now father transferred the land by way of a gift to the, my lord, the daughter. The daughter now before your lord.
এটা কোন সালে?
It was 2021 সালে. Before that, my lord, in 2017, he also filed an application. Same
No, no, very good. He is wanting this prayer not to demolish the unauthorized construction in plot number 33360.
Yes, that
This
is
is in front of 3359.
Your plot is
3359.
Our plot is
2859. Plot number 3359. Yes.
In front of the 3359, there is a PWD land which actually acquired 3360, which actually acquired by the PWD for the construction of the road. There are left out.
Let us understand. He is 3359. Right. You are the occupier of the adjacent plot 3360. So the building is in 3359.
There is no building in 3359.
Then which building he is talking of?
My building.
This is not.
First, he filed for demolition. When the demolition, my lord, there is an order by the Honorable Court to demolish the building, but that was not, my lord, culminated as yet. My lord, for that reason, he filed an application for the writ petition to construct a grill gate in my building, to occupy my building, to grab my building, my lord.
My lord, may I suggest one thing? Your lordship kindly deputy special officer, they would visit, they would file a report, then my lord, your lordship. That will be
My lord, one map, my lord, I have annexed, my lord, one map. Kindly have a
nobody is
take
giving the clear picture.
This map also, my lord. Sketch map. Where is building situated, my lord? 4, 5, after 6 page, my lord. This report.
Disputed question.
After 6 page, my lord, this is the sketch map showing.
Yes.
But kindly have a look this building, my lord.
This sketch map.
My lord.
What you are showing?
My lord, this building, where is my lord constructed this building, my lord, middle portion of this
3359.
So
no.
This is the building, this is the staircase. Yes, what you are showing?
No, my lord, 3359 plot number, and my lord, this building
Is on a certain portion of 3359. Now 3359, he is the owner.
My lord. That's why, my lord, I showing before your lordship. This is the sketch map.
Then where is this person residing?
No, my lord, I not say, my lord. This is, I have no instruction, my lord, where he is residing, my lord.
No, my lord, PWD in his report, it is clear that building has builded upon the PWD land. And some encroachment has been made. My lord, it has annexed in our report, my lord. Kindly come. Annexure A.
Mr. Mustafa, you are not being able to satisfy us. This is a huge dispute.
My lord,
I do not know who is who to whom the building belongs, who are the residents. You've preferred earlier writ petition. That also it ended up in about demolition of a property. He says that he is the
No, you're
occupier
not.
of the
That's why, my
demolition.
lord, if a special operator is, because it is at Sampur, Howrah area, because our case is that on only 3 decimals of land in plot number 3359.
Establish your title, get a civil court order, then you come to us for implementation of
Law, my lord, land was relinquished, that portion was given to us, wherein, my lord, we have constructed the house.
The present appeal has been preferred. Challenging an order dated
But
12th of March
my
2020.
father is a dying condition. Civil court, my lord, it will take long time.
Mr. Mustafa, we tried to be in your favor, but we are unable to do so because you yourself is not.
My lord, what documents, my lord?
We asked for sanction plan. You are
That is
not
admittedly not there.
You have not shown us any documents save and except the statements made in paragraph 4.
No, that statement is supported by not page 43 and my lord, record of rights.
Record on the basis of record of rights, Mr. Mustafa, can we
Can
decide?
title, but my relinquishment.
You may be a part owner of the property. We are not concerned.
But my lord, the relinquishment order is there in my favor.
Very good, but the building has been constructed by you. You are not being able to show us the sanction plan.
Plan is not there. But
So if plan is not there, then it is an illegal
admittedly, my
process.
lord, I am residing, and
That's
for
our
safety, my lord, for safety, a gate is necessary.
আর কি করবো তাহলে আর? Challenging an order dated 12th of March 2025 passed by the learned single judge in the writ petition being WPA 28900 of 2024. তুমি স্লিপগুলো নিয়েছো, অ্যাডভোকেট গুলোর নামগুলো নিয়েছো? তোমরা যখন প্রথমে বসবে তখন নাও না কেন? আমি তো ভুলে যাই, সেই জন্য এম্বারেসমেন্ট হয় এত। He said writ petition was preferred.
I'm grateful.
Hey, please, your lordship, I am for the appellant. My lord,
I'm for the railway.
as per your lordship's kind order, this is the supplementary affidavit. My lord, the plots have been cleared out. The plots, this is relating to the license matter where the demolition occurred during the course of the day, course of the hearing on 21st May. So my lords had been pleased to direct to file a supplementary affidavit because I prayed for time to clear out our valuables. Whatever was possible, it has been cleared out. Nothing remains. But my lord, there is only one prayer. This is an additional prayer. It is mostly coming from the bar, because I could not take care of my clients. So may I be, with utmost humility, may I make, there is a small portion in the eastern side of the siding, very small portion. If there can be a temporary accommodation for the appellants herein to carry out some kind of business over there, because it is adjoining.
First of all, there was no latches on your part. You have submitted the truth before the court.
Lordship, but
so there was no latches on your part.
And my lord,
Your client should not misunderstand you. You tried your best. Your whatever document you had, you placed. Order was ours. We refused the order. Why you should be blamed? It is not a case that you did not appear in the matter or you did not give the documents.
In
But
addition,
then what remains in the appeal? Nothing.
Remains in the appeal. And my lord,
Then
there
what
can be
this
some
additional
little
prayer
relief, a very small relief. These clients, these appellants have been blacklisted by the railways. No, blacklisted.
Where
So,
is the order?
my lord, there is it's very unofficial. Even if they apply further for some other plot in some other railway siding in the eastern region,
If they do not consider, come to us. There is no blacklisting here.
if there are lordship.
Tender pertaining to the property or railways have different tenders, na? You must have the qualification to participate in it.
Oh, no, that is only that I can only apply on the conditions of the tender, only on the conditions of the tender. But a siding plot, a license, there are other, they can always make an application. So,
No, but as of now, there is no determent for them to not apply to other such siding plots.
well, then I'll make them apply. If there are other options,
If it doesn't work, then you come back.
lordship, lordship.
Where is the order, impugned order? In the appeal?
My lord, volume 3, pages, my lord, annexure E, volume 3, of the stay application, pages 513, 513.
And the writ petition prayer portion, where is that? Writ petition you have annexed, na? Yes, we have got it. Page 276. This is your writ petition, na?
The writ petition, prayer is page 83, volume 1.
83.
83.
So you prayed for regularization of your occupation of the said land.
Not just regularization. It was that the calculation of the license fee was challenged by itself.
The enhancement was challenged. The enhancement made was
Enhancement, not only the enhancement. What they had done was, this writ petition was filed in the year 2004. They had back calculated the land value. Land value has its own life when it increases. It was highest at that point of time in 2004. They had back calculated it. And with an increase of 10% per year. And at that point of time, the circular, the original circular and the previous orders passed since the 80s, it was 6% per every 5 years.
The plot of land was the same.
Lordship, same.
এটা নোটিশটা চ্যালেঞ্জ করেছিল নাকি? অ্যাডমিনিস্ট্রেটিভ লাইসেন্সটা চ্যালেঞ্জ করেছিল কি? এখানে প্রেয়ারে পাচ্ছি না। 2004-এ প্রেয়ারে তো দেখছি E11 টাই। in the writ petition. Page 83 টা prayer টা দেখো। You challenge the termination of license in the writ petition
Also, Lordship, because the original,
because the
because
back
the impugned, my lord,
because of that, na.
because of that, they had raised that if you do not pay arrear dues from 2004 backwards up to 1992, then the license agreement shall be terminated and
You
shall.
tell us, Mr. Bose, what protection you want. We are going to record it has become infructuous. What observation you want in your favor? Tell us.
If there is a possibility only, this thing, that if there is a
So that,
possibility.
Mr. Bose, we cannot, because if there is any adjacent plot, whether
No,
it will
not plot. Any possibility of an alternative accommodations, they may be allowed to apply and be considered if possible. If possible.
is there any such, is there
Because, my lord,
any such,
may I interrupt, my lord? Because there was a possibility, because the Kolkata station, which is now there, was originally a siding. And all the plot holders were allowed to take plots in Kollani and parts of Andul. So, my lord, alternates will come out where there are smaller stations or medium-sized junctions, there would be sidings.
So, can we record that in the event there is any rehabilitation scheme of the persons who have been?
As per my instruction, there is a vacant land, including the plot holder of unoccupied plot holder. There is a project is there. 24 LBS coaches project will be constructed there. That's why, including the vacant land as well as also the unoccupied plot holder who has been already evicted, all the areas has been required for that purpose. That's why vacant land as well also is the.
No, very good. Are you? Is there any scheme for rehabilitation? Nothing.
No, ma'am.
Well, the scheme can include not just one single plot, because this is the Eastern Railways. Eastern Railway starts from Mughal Sarai to up to Kolkata and up to Assam, any part, if possible.
যেটা তো এভিকশন হয়েছে
না
প্রজেক্টটা না, এটা ওদের এটা ইনস্ট্রাকশন, যেটা কপি দিচ্ছি না।
Termination notice being bad in the. এদিকে ওটা কত কোন সাল? হ্যাঁ, এটা termination.
Just যতটা
Cannot insert the future work steps and
তোদের ইস্টে তো জায়গা আছে, স্পেশালি ইস্টার্ন সাইডটা তো ফাঁকা জায়গা।
No, we can make this observation that in the event there is any rehabilitation scheme, they may be the evictees, may be the persons who have been evicted.
If there is any scheme, they will apply and it will be considered. But it was, but it is not out of instruction actually. As per my instruction.
So, like when somebody is removed and the plot is taken over, usually the model employer makes a rehabilitation scheme. But we don't know railways what you are doing.
Actually, when the project was, this is a coaches will be constructed.
What fell from your lordships? If your lordships may be pleased to add, it shouldn't be particularly limited to Shialda only. Then it
Mr.
opens
Bose,
up.
show us something. Then show us something that this is the scheme. You say that dismissal of the appeal will not prevent us from applying. We will pass that order. Give us some handle, then we can say. Otherwise, how in the cloud we can say? Na?
Well, that is actually only my learned
Now,
friends.
if this cannot be this demo, this eviction, they will the eviction. We cannot also say now that don't take any coercive steps against them or don't prevent them for entering. How we will say without any? Tell us, give us some material.
If and it at all comes up, when it comes up,
That becomes a bit vague, na, Mr. Bose. That becomes a bit vague. They are all statutory bodies, and we cannot put things in his mouth. Also, he
My lord,
will
I also do not want, because
that
it is
you will
beyond his
also not
instruction.
So that as presiding over the bench, we must remember that na advocates are hauled
That
up for some.
opportunity is, my lord, if I may make a submission again off the record. Off the record. This is one of the biggest institutions of India. Just this case, just these names, because railways will always have a record. I prayed for that line because this will itself put them under the radar. That every time they come, they are going to look for if they have filed a case against the railways or not.
You come to us, then the door is open. If for this reason, for the alleged illegal occupation, you are debarred from participating, you come to us. That cannot be done.
My lord.
Sorry, Mr. Bose.
My lord, I can't actually make more submissions on this.
The records reveal that the petitioners were
My lord, I'm applying for the respondent PF authorities, my lord.
My lord, I am, this is the affidavit of service, my lord. I have filed. My lord, the case is this, my lord, there is a section 5 application.
Go to that.
Illogic, kindly take it up.
No, no.
Illogically,
21st, my lord, is
illogically see, but illogically take it up. Source, what matter, illogically, it will be disposed of by today. Entire appeal will be disposed of by today. You'll also kindly see that. I shall take only 10 minutes.
No, no, what is the urgency?
Well, urgency is this, my lord. They have issued a certificate proceedings. Otherwise, my lord, the bank account will be seized of FCI.
When was it issued?
My lord,
Certificate proceeding initiated when?
It was initiated, my lord. It is initiated on April 2025. Well, after, my lord, I have written several letters. Well, that's why they have not attached. It was kindly, it will be disposed of within 10 days.
Disposed of by what? We have to set aside that.
Well, I am not praying entire thing. You kindly hear me. I'm not. You kindly hear me for a moment. But there is a section 5 application. There was a delay of 65 days. That is kindly hear.
By study.
But there is a lordship. But question is this, my lord, otherwise, my lord, they will proceed. If they do not proceed with the
formal order, my lord, formal certificate, my lord, my lord, no attachment order has been passed, my lord.
If they don't,
after end of the every financial year, my lord, we have to submit a certificate.
So the first nail was the honorable judge is returning on 21st. The second nail is that your appeal is also barred by limitation.
I have tried my level best everywhere, my lord. That in that bench, my lord, I have mentioned, my lord, kindly hear this.
That cannot be a ground.
Your lordship, 10 minutes it will be taken up. Well, I shall only pray for going. Your lordship, kindly. Well, I have, your lordship has allowed me to.
Yes, next matter. Sorry.
Well,
Lord,
they will not take any coercive step until that matter is hard. Your lordship, it will be. Your lordship,
There
kindly.
is no possibility. Why you are unnecessarily worried?
There is a possibility. We also kindly see there is a possibility, but they will.
So if there is a possibility, we have to condone the delay. Thereafter, now we can take it up. And today we are on Thursday. My lord is returning on 21st. Chalo. Sorry, sir. Don't worry. Yes, next.
Lord, I am appearing on behalf of the respondent.
Lord, I beg to appear for the appellant. Lord, am I audible to all officers, Lord?
Yes.
Am I audible to all officers? I beg to appear for the appellant. Lord, the respondent appellant. Lord, am I audible? Lord, the impugned order, Lord, by the impugned order, Lord, the learned single judge has reviewed her earlier order. I'm sorry.
বলে যাও তাহলে। অদ্ভুত।
Lord, I could not follow, Lord. I could not follow.
It reaches you later. Buffer zone. Why you are before us, Mr. Majumdar? 21st, my lord is returning.
I am responding.
Lord, I have suffered. Lord, I have suffered the interim order. Lord, I have suffered the interim order. I tell you, Lord, what happened. Lord, kindly not just hear me for a minute.
Yes.
Lord, I have suffered the interim order. Kindly hear me for a minute, Lord. Lord, the matter initially filed by me a writ petition for recognition of a trade union. The Honorable Single Judge directed the authorities to not verify the records and take steps. Lord, Mr. Majumdar's kind filed a writ petition, another writ petition, praying for review of the order passed in the earlier writ petition. And Lord, the Honorable yes, kindly see the prayer, and the Honorable Single Judge has reviewed the order and stayed her earlier order. Lord,
and
I cannot say that.
Final discussion.
My lord,
matter on 15th June and fix the matter on 8th.
Yes, then it is not taken up. Lord, we filed the appeal. Appeal is not taken up. Lord, their only ground is that it should not be done by central authority. It should be done by state authority. That's their only ground. Their only ground is that the Barnpur unit of the state
will decide that, Mr. Chakraborty. Why you are so worried?
Lord, the election is stopped. The election date is over. The nominations are
as
filed.
per the election program, nominations have been filed.
And at that point of time, it has
you
been stayed.
decide the writ petition goes in your favor. The date will be fixed for final election.
Date has expired. Notification is expired.
Yes.
Which
Yes, that this point will be taken now. Now this point will be taken. They got a stay. But kindly see the prayer in the writ petition.
suppose
Now
if it,
kindly see the prayer in the writ petition.
It would be fresh notification because the date of
Kindly see the prayer in the writ petition.
why it cannot start from the point when it is ended?
Yes.
Court can always not
Kindly clarify that. Not I have no problem.
always the point the relief. Yes,
It is not a total full stop.
no,
it
no,
will
no,
be-
no, I am never saying so.
Yes.
It's an
Yes, Mr.
intermediary-
Kindly clarify that. But my lord may clarify that. My lord may clarify that. Direct the single judge to hear the writ petition within a particular time.
Returnable petition. 30th June.
My lord will kindly clarify. My lord will kindly clarify that and will not direct the learned single judge to hear out the writ petition within a specified time.
Not entertaining your appeal, Mr. Chakraborty. The appeal, what is the tearing hurry that we should interfere today and pass an order?
Prima facie view has been expressed.
You have to go to the single judge. If ultimately, if you are unsuccessful, come back to us. A regular bench
Lord, I am praying for that only. Lord, I am praying for that only. Kindly do not send it to regular bench. Kindly pass an order, dispose of the appeal. My lord may direct the single judge to decide the writ petition.
Decide the
Direct the single judge to decide it.
We are not taking it up.
Lord, the
Court can dispose it off.
my lord may
kindly dispose
Lord,
it
the
off.
difficulty is that not from 8th of May we could not get it hard. From 8th of May we could not get it hard. From 8th of May.
Why haven't you come physically? Where are
That's
you?
right.
Lordship, he is at Delhi.
Lord, I have come to Lord the circuit, Lord, to Lord the circuit bench. That is the difficulty. Lord, I'm sorry, Lord. I apologize with folded hands, Lord. I should have been there physically, Lord. I apologize, Lord. I am very sorry. I'm very sorry, Lord.
Expect you to see.
Kindly, Lord, direct the honorable single judge to decide the writ petition within a particular time.
Yes, we could have.
That will resolve the issue, Lord, because I understand it's an
Don't ask us to say anything. You go to the regular court. Otherwise, we take up the matter and prima facie subject to what you say. We have to enter into the matter then. And it is you are already in a
very well. Very well.
Understand?
Very well, Lord. I don't want to embarrass your lordship, Lord. I'll go to the.
Not a
I
question
don't
of
want to embarrass your lordship. I'll go
order
to
may
the-
embarrass
very
you.
well.
This is next.
Very well, Lord. I'll go
You
to
want-
the. I am, but it's coming a little late. Coming a little late, your lordship.
Rajushree got it.
Group 3. In group 3.
এটা বলতে পারি next so no interference is so what
No, Lord, do not record that. Then the appeal will go. Do not record that, Lord. My lord may direct the single judge that since it's against an interim order, you will also request the single judge to decide the writ petition.
no in that case
Do not go into the merit.
your
Do
appeal
not go into the merit since it's against an interim order.
Mr. Chakraborty, we will only say that from the records we find that the single judge has made the writ petition returnable on such and such date.
Yes. Yes.
In view
Yes.
thereof,
Yes.
there is in the view there no interference is called for in the present appeal.
Yes.
Your appeal will get
Well,
disposed.
only
Lordship.
one request to the single judge to decide it not as expeditiously as possible. One request from your lordships. Only one request. Only one request. Not that is what I'm asking for. That is what I'm asking for. Nobody would be prejudiced. Mr. Mujumdar's writ, I am asking for an expeditious disposal.
সবই রেডি আছে সবই রেডি এইগুলো সেগুলো কি বলে বলে তো নেক্সটটা দিয়ে দিই দুজনের 6 and 7 অ্যাটেন্ডেন্সটা দিয়ে দিয়েছিস তখন
The learned judge perhaps followed pseudonym, but they did not consider it was Supreme Court. Pseudonym was distinguished when it was Supreme Court.
Mujumdar, how you could have prayed for review of an order?
Yes.
Again,
Yes.
61 Supreme Court.
Yes. Now, kindly consider 74 Supreme Court. Sivdev Singh has been distinguished. Kindly, Mr. Ghosh, kindly hand over 74 Supreme Court to the Honorable Court. It has been distinguished 61 Supreme Court. Sivdev Singh has been distinguished by the Constitution Bench.
Point
That
was
it cannot be done.
by the single judge.
We will
Whether-
consider. But in any event, that the previous order does not bind us because we were not parties.
But the rate is not maintainable.
But the beginning line of
So, the rate petition is.
you are in review.
Yes.
Very well. But that's the court. There are other players as well. The court can consider that.
বেরিয়ে গেছে 61 সুপ্রিম কোর্টে সেখানে হচ্ছে তুমি যদি হ্যাঁ
And my principal prayer is to set
No,
aside.
see the prayer ones. Kindly see the prayer. Kindly see the prayer ones, page 46 of the prayer A. How can the writ petition be maintained? Prayer A, kindly see page 46.
For mandamus.
Kindly see what is the prayer. Review of the order dated so and so, passed in WP number so and so. So there will be no leave to appeal, no appeal with a leave to appeal application. Everywhere there is a non-party, he will come and file review. That is a clear departure from the settled procedure.
24 Supreme Court was dealing with a
Your
different.
60. No, kindly see the 74 Supreme Court para 11, Lord. Kindly have a look at the Constitution Bench judgment.
The subject matter of challenge in the present appeal is an order dated 8th May 2025, passed by the learned single judge in the writ petition being WPA 10299 of 2025. Mr. Chakraborty, learned advocate appearing for the appellant, appearing for the appellant stroke, appearing for the respondent number 8 in the writ petition stroke appellant hearing.
Right.
Submits that the writ application itself is not maintainable.
Grateful.
As by the same as in the same, the prayer was for review of an earlier order dated 25th February 2025, passed in WPA 27274 of 2024. He further submits that the learned single judge are in interfering with an election process which had already started much prior to, which had already started on 28th of April 2025. Stop. Such contention of Mr. Chakraborty has been denied and disputed by the learned advocates appearing for the writ petitioners and the
Other respondents.
and the other respondents. Stop. Onaদের appearance দিয়ে দিও. Stop. In course of hearing, we have been informed. A perusal of the order impugned reveals that the matter was that the writ petition was made returnable for hearing on 18 June 2025. Today, we have been informed by the learned advocates respective parties that the next date fixed for that the next date of hearing has been fixed on 30th of
Final
June.
hearing, my lord, final hearing.
Next date. You have exchanged your affidavits and everything.
My lord, but the learned court
chosen not to
directed
use
for
as of date.
the exchange of the notes, my lord.
The next date of কি লিখলে? We have been
Final hearing.
informed by the learned advocates appearing for the respective parties that the writ petition the next date of hearing has been fixed on 30th June 2020.
Yes.
As the writ petition has been fixed on 30th June 2025, we are of the opinion in view thereof, no interference is called for in the present appeal. No interference is called for in the present appeal. The appeal and the connected application are accordingly disposed of. Yes, sir.
Deeply obliged to lordship. Deeply obliged.
Only one request for the learned single judge not to decide it not within a time. Not that, not within some time to decide that.
Mr. Chakraborty, now we will drag you to court from Delhi.
No.
Further, sir.
Andamans.
Andaman.
An India advocate.
Therefore, it warrants a dismissal, not a disposal.
Andaman, if he
request
he has 450, he has finished his job.
An India advocate.
And he is no longer visible.
Kindly request the single judge to not decide the writ petition within a time not including the point of maintainability. Not only that request.
It up before the honorable single judge.
Obliged to lordship.
It will be better for you.
Not only that request within some time.
These 3 dates of hearing should be.
Within a time frame.
Yes.
Not including the point of maintainability, under judge will decide with them.
My lord, may I take back orders?
কোনটা? হ্যাঁ দিয়ে দাও।
23, my lord, in this matter, my lord, I am appealing for the respondent.
Lord, I am for the appellant, my lord. This is a probate appeal. It will take some time.
My lord, one thing, my lord, this is a condition. The vast property.
My lord, if your lordship kindly fix it on
Anytime, my lord, I have no objection. My lord,
26
9 days.
26
9 times this.
আমাকে বলতে দিবি?
না স্যার, আমি ওটা নিয়ে বলছি না স্যার।
Yes, sir.
Either 26 June or my lord 30th June, if your lordship can fix it.
We cannot fix it. This is the problem. Now we cannot having assigned matters. Why assign which court it was there?
It was initially the determination lies with my lord Justice Shane. He was the counsel in this matter. When he was in this side, my lord admitted that.
My lord, initially this matter appeared before your lordship while your lordship was sitting
Sitting
in
in number 28.
centenary building.
32.
Then, my lord, there was a copy of the will was not there. Your lordship directed the matter to.
After that,
get
my
the
lord,
copy.
the
Then it
judgment
has
was sought for.
Thereafter, my lord, it has
Lots
come
of time. Now the property is going to be ruined at any point of time.
26 June. Or
not on 2nd, my lord, and not on 25th.
26. How long will you take?
But I shall take about
Notes of
Sheila Diaz.
about 2 hours.
We'll take half an hour. We'll take half an hour, not more than that.
My lord, my lord, kindly let his submission be noted,
Yes,
my lord,
yes,
that
yes.
he will take only half an hour. If
Yes.
it takes more than half an hour
My appeal,
or more than one day,
appeal will be allowed.
That is your choice. If you don't finish your argument.
Yes, I know. That is why precisely, my lord, I'll come.
আমাদের ইয়েটা কবে আছে এমআর ডিলারদের মামলাটা কবে রাখলাম 2 p.m. So they কি একটা
17 July to
2 p.m. ইংরেজি কথা বলতে কেউ ইংরেজি কথা বলেছি
that will tilt the scale.
due to paucity of time, the learned advocates appearing for the respective parties could not complete their arguments. In view thereof, leaves the matter for further consideration in the daily supplementary list of this court on 17th July as fixed at 2 p.m.
Grateful to Lord. Grateful to Lord.
Yes, ডেকে দেওয়া হচ্ছে। কি assignment?
চলে যাই। বড় ঠান্ডা একবার। দাঁড়িয়ে রইল কেন?
না, এই যে নামটা চাইলো।
My lord, I am for the appellant. This is a civil first appeal. It will take some
Just one moment, my lord. I would like to seek leave to retire from the matter because I'm unable to contact the clients. I have even issued letters to their residents which have come returned. So I have no option. I am for the defendants and the respondents. Defendants.
Very good. Keep it with you. We are not taking it away. We will not be able to finish it.
Today is not possible, my lord. It will take some time.
Cholo.
My lord, kindly takes it next week, my lord, not
Fortnight.
I'm grateful.
এই 25 নম্বরটা yours is 24.
24.
20 তাহলে আজকে বৃহস্পতিবার তো থার্সডে উইক করে দেবে। Thursday week.
Grateful, my lord.
Yes, Mr. Banerjee?
No, I'll not take the risk. Suppose my lord fix up on 18 July, but before that matter can be heard. But once it is fixed 18 July, I can. Grateful.